on the last two consecutive dates, the matter didn't reach, and it involves, my lord, compassionate family pension, provisional compassionate 16 of life.
May I please, your lordship? We are called listing lordship, matter relating lordship, pensionary benefit lordship.
16.
Item 1 of daily leave. May I please, your lordships? This review petition so many times hard and lordship fixed for
Are you ready?
Lordship,
no affidavit.
Lordship, we were supposed to file additional affidavit.
Yeah, where's that affidavit?
Lordship, but the department have instructed that they are relying the affidavit in opposition earlier filed. Lordship, they are not going to file any additional.
No, but
affidavit.
then there was a direction from this court, isn't it?
So since Lordship, it is not reflected in the order, they said that it may be relied the earlier affidavit in opposition.
No.
There already affidavit is there in the review petition and the review petition also.
Affidavit is already Lordship, since they have not signed it, so it could not be filed.
Then let them sign it, because this court has passed an order to file an additional affidavit. You file it within 1 week time. We'll take it up next week.
Lordship.
My
Lordship,
learned
the order
friends,
may be, it may
my
be
learned
reflected in
friend-
the order, Lordship.
my learned friend says the department are not ready to file that additional affidavit. That may be recorded, so lordship may proceed.
You are not ready to file that.
Lordship, already affidavit in opposition filed, Lordship. Additional affidavit, Lordship has directed to file additional affidavit in view of the scheme of the compensation appointment. But since the order has not been reflected and they have said that they are relying the affidavit in opposition already
It's up
filed,
to you then.
Lordship.
Yes, proceed.
My friend says they are reluctant to file additional affidavit. They will depend upon the affidavit filed in the review petition on depend upon this.
Hmm.
Lordship may take up the matter on this point.
Okay.
Today, lordship, I will proceed, lordship.
You are ready otherwise today? Okay.
Lordship, here is the case, petition number 1, 2, 3 are engaged on compassionate ground. One,
That is the issue why I said to
Yes,
file the
lordship.
additional affidavit.
It is compassionate
Because
appointment or not,
This is a
Lordship?
compassionate appointment.
what,
Yes, Lordship.
that,
So you are not filing your affidavit, that means what
Yeah.
the petitioner is saying is correct.
Lordship, as per the scheme of compassionate appointment, it is not a compassionate appointment.
But that's why we said to file an affidavit stating that this is not. a
Lordship, one more last opportunity may be given. I will contact the department, Lordship.
Okay, one last
The order
chance.
may be, it may be reflected in the order, Lordship. Earlier also they have said that there is no order. We are-
Order is there.
that document says they have engaged on compassionate ground. Their own document says engaged on compassionate ground.
First, Mr. F. U. Barwell, then it comes to the petitioner. MSR Devi, then it's CGC. Place for filing an additional affidavit as last chance
Lordship.
Yes.
to indicate that the petitioners were not appointed on in terms of the scheme of the compassionate
No.
appointment of the central government,
No.
correct?
Lordship.
So. List the matter again on when
Prior to vacation,
immediate
lordships.
you want 1 week, 2 weeks,
2 minutes, Lordship.
On Thursday. Next
12.
Thursday.
12.
12.
Of Lordship.
Lordship, I'm praying for timing of this matter, Lordship, just for it's a apology, Lordship, the part of matter, Lordship. Just for a few minutes, Lord.
sometime you want.
Sometime, Lordship.
Okay, not urgent.
Also for time being, Lordship, today only, Lordship. For time. Much.
Item 4 to 14.
May I please, Lordship? Lordship, kindly pass over the matter for the time being. Mr. A.R. Bhuya is on lag at another.
Who?
A.R. Bhuya, Lordship.
The Lordship, in this, otherwise also on last occasion, we were directed to, the DC Dhubri was directed to obtain instruction. That instruction is awaited. We have written to them but till so far we have not received. So may I pay after immediately after vacation? By that time we'll get the instructions on that matter.
Lordship, if any subsequent developments had taken place in these days, the leading council will definitely apprise you. So Lordship, take up the matter after some time.
But he wants an adjournment. He said he has not got the instructions.
Instructions are available.
In terms of which order?
14/9,
14/9.
and also 8/8/2020.
Already affidavit filed.
My lord, there is an order, my lord, to file an affidavit by the revenue department, my lord, and that has already been filed.
Hmm.
Now, my lord, another issue is there.
Are you filing any reply?
To that effect, my lord, at this moment not required, my lord. And my lord, another issue is there. There is a, what has happened, my lord, this election, which has been done, my lord, pursuant to the liberty provided by this honorable court. There is a large scale anomalies has been detected, my lord. And we have also filed a writ petition challenging that selection process as well as the appointment of the private respondent. Now, my lord, what has happened? An FIR had also been lodged before the, my lord, Anti-Corruption Bureau of the Chief Minister's Special Vigilance Cell. And after, my lord, conducting investigation, the Chief Minister's Special Vigilance Cell has already filed a charge sheet against all these persons involved as well as those officials, my lord, who were carried out this selection process were also behind the bar also, my lord. Now, my lord, that's why we are, my lord, we have prayed before this honorable court to bring the record in original, my lord, to peruse this before this honorable court, and this honorable court has directed several occasions, my lord, to produce those records. But till date, my lord, those records are.
You
not
have the
available,
records.
my lord.
Your lordship, revenue. DC office, your lordship, DC every office will have to actually.
No, it is in the custody of Chief Minister's Vigilance Cell, my lord, not in the
Mr.
DC's
Nath?
custody.
But some records, certified copy of some records we have already received, like, from the investigating officer. And here, my lord, ultimately on 8/8, Lordship has directed us to obtain a specific instruction. That instruction we are awaiting, my lord.
Revenue and disaster minister, they filed your affidavits.
And after the revenue letter, what has happened, what the steps the Deputy Commissioner Office has taken in person to the revenue letter, that, my lord, we are required to place before that.
How much time you require?
We are awaiting, my lord. Lordship may give us 2 weeks time, my lord. We have communicated, my lord. 2 weeks time may be given.
Yes,
Lord, if
On reopening.
My lord.
Heard Mr. A.R. Buyan, then the counsel for the petition. On request made by Mr. D. Nath, Leonard Senior Government Advocate. 3 weeks time is allowed
Mal-
to enable him to receive instructions in terms of the order dated 8/8/2009,
Lord.
2023. Stop. You want a date?
My lord, will be
This. Again. 9th.
9/11, my lord.
It's
Ninth,
9th November.
Obliged. Obliged.
15.
May please your lordship. Lordship, matter relates to non-regulation of the leave period of the petitioner lordship. Lordship, this honorable court on 24/3/2023 directed the petitioner to file a representation before the director lordship. Accordingly, I have filed lordship, and last occasion they informed the court that lordship matter is pending before the secretary for final disposal, that my representation is pending before the secretary lordship.
Yes, who's appearing? Yes, Trishti.
Yes, Lordship, Lordship may kindly permit some time, Lordship. The records are not here with me, and Lordship, I'll have to get the instruction, Lordship.
With a consent lordship, next week any date. Lordship.
Next week, Lordship.
Okay, heard MSP Bhattacharya and then counsel for the petitioner. On request made by Assembly District. Standing counsel,
Secondary education lordship.
secondary education, list all,
Salary pattern हो जाना. Salary pattern हो.
21.
20. Yes, lordship. Yes, 21.
Huh?
21.
20
अधिकमान try करो.
October.
12th.
Yes, your lordship.
Yes.
12.
12th October.
Apply Lordship. दिन किया जाना है।
Apply you.
16.
Made please.
Yes.
Lordship, matter relates to family pension, Lordship. Lordship, the petitioner has submitted, Lordship, all the required documents, Lordship, prior to the latest direction of the Honorable Court, Lordship. If Lordship permit, Lordship, I.
One minute. Yes.
Lordship. Lordship, petitioner submitted, Lordship, on 5/8/2023, Lordship.
5.
5 August, Lordship,
Uh,
2023.
That was prior to the order passed by this
Lordship,
court.
Lordship. Lordship. Respondent told that petitioner has not submitted, Lordship. That's. Well, no, I can't do this. I would think. Pass after this.
Yes.
I had the latest instruction. 28/7.
It is 5/8. Proper.
28/7 is a instruction after the, before the order was passed.
Thereafter, I did not get any instruction.
This order, this is an outdated instruction.
My lord,
Order was passed on 22/8/2023, directing the petitioner
Yes.
to submit all the documents. Now he has submitted the documents on 5/8/2023.
yes, ma'am.
Now the issue lies with you now. Now whether you have issued the pension.
But in that case, my lord, I'll have to have the updated instruction. Because after this instruction, my lord, from the petitioner side, my lord, I did not get chance to.
You take instructions. Mr.
A. Sharma, Lordship.
A. Sharma, learned counsel for the petitioner. Submits that the petitioner by an application dated 5/8/2023 had submitted the next of kin certificate, comma, single photo and group photo as required by the concerned department. Stop. As required by the concerned department for payment of family pension on the date of his wife. Stop. Mr.
Yes, sir, Rabba, my lord.
S. R. Rabba, learned standing counsel BTC. Praise for,
Yeah, my lord.
how much time you require?
2 weeks, my lord.
Praise for 2 weeks time to enable him to receive instructions. Praise allowed. Please stop.
I may be furnished with the copy of the instructions that they have submitted, my lord, in the court.
That you have already submitted. That's the same one.
This.
Yes.
Match.
All right.
17.
Lordship, may I appear the date may be fixed. Lordship.
After 2 weeks, today is third. 1, 2, 18th October.
Potential non-payment of family pension, my lord. Father of the petitioner for service as master roll worker, my lord. He served more than 20 years service, my lord. And subsequently he retired in the year 2001, my lord. And subsequently he died on 1st of November 2012. And thereafter, my lord, the terminal gratuity was paid in favor of the brother of the petitioner, my lord. Page 27.
Do you have the regularization order?
My lord, I filed additional affidavit, my lord.
When did you file it?
Additional affidavit filed on 26/6/23. Order page 50, my lord. And 49 is the type copy, my lord. Subject regulation of service of Sri Bonti Das, retired Master Roll Rebat. I am directed to convey and sanction of the Governor of Assam towards creation of the superannuary post of grade 4 in the scale of test and plus other elements. The last day of service of Sri Bonti Das, retired Master Labor for regulation of his service to extend pensionary benefit to him as per rules, subject to the condition that no any person will be engaged against Sri Bonti Das since he was a master roll employee in the context of financial. It is the regulation order. my lord.
Yes.
That is good. My lord, only what I need to take an instruction from the department is regarding the only regulation, though it's seems, but it has come from an RTI reply only, my lord.
No,
Otherwise,
Page 50 of that is the regulation order.
ಇದು ಬಂದಿರೋ ಆರ್ಟಿಕಲ್ ಅನ್ಕೋತು ಅಂತಿದ್ದು ಇರ್ಬೋದು ರೆಗ್ಯುಲೇಷನ್ ಇದ್ರೆ ಅಷ್ಟೇ
Subsequently, my lord, the terminal gratuity was paid, my lord, only because of that, my lord, he has done less than 20 years of service, my lord. After deduction of 6 years initial service, my lord. And 6 years service, deduction of 6 years already, my lord, held arbitrary by this honorable court by Sanjita Roy, my lord. Then, my lord, after, my lord, that, my lord, the service of the father of the petitioner took, my lord, meets 20 years of service, my lord. Then he is entitled to pension, my lord. And subsequently, my lord, the petitioner is the unmarried daughter, my lord. And in pursuance of the page 36, he is entitled to, my lord, family pension, my lord, as per notification dated, my lord, 9th of August 2018, my lord.
Where's that notification?
Page 36, my lord, of my petition. By this notification, my lord, the rule was amended, my lord.
Yes, that.
my lord, let me seek instruction on this additional affidavit. My lord, post this matter next week.
Okay.
My lord.
But Mr. Kia Patkari, then I consult the petitioner. The petitioner has filed an additional affidavit,
Petitioner.
enclosing the regularization order of the
Father of the,
of her deceased father,
Mother.
dated 30 November 2005.
5, my lord.
2005. Para Mr. Ardhar and the additional senior government placed for a short time to enable him to receive his payments. This is the matter. When do you want?
Next 13, my lord.
13th.
My lord.
Oblige.
18.
My lord.
This is a matter, my lord, wherein, my lord, he seeks interest upon delayed payment. But one vital aspect was, my lord, it was not whispered. That delay was due to him, my lord. He marries twice and we sent the papers on time, AG 6 clarification. That is, there's no whisper about that, my lord. And apart from that, my lord, the rule stipulates that the secretary is to take a call. And
No, the issue is that you have initiated the proposal for payment of
no, there are twofold issues, my lord. Main issue is he seeks payment, delay, interest on payment. And the delay, my lord, is totally due to his fault, my lord.
what is this?
This is order, my lord, previous litigation, my lord, wherein, my lord, this issue came before the court, my lord. We had forwarded the papers on time. There was a dispute between these two wives. 197. 97A. কথাটো কোৱা নাছিলে নেকি? মইতো কোৱা নাই সেইবিলাক। নাই কোৱা ন?
Yes.
My lord, actually, he was directed to submit the compliance report on the area amount of delayed payment, my lord. Earlier order, my lord. Can you see page 11, my lord? Page 11, para 21. Para 21, my lord, page 11.
Oh.
197A, my lord, interest on delayed payment of pension and gratuity, my lord. If the payment of the pension or gratuity has been authorized later than the date when his payment becomes due, and is clearly established that delay in payment was attributable to administrative lapses, interest shall be paid at such rates as specified under sub-rule B of this rule, and instruction issued by the government from time to time.
Yes.
Provided, actually, he was, my lord, directed
My
to,
lord,
my lord,
entire-
high compliance report,
No,
my lord.
my lord,
Not
that
to
was
submit
different.
this order, my lord.
No, my lord. My
Can
lord,
you
will
see the
see,
earlier order, my lord?
my lord, see that earlier order was regarding his area payment, which is without the component of, my lord, interest. Here, my lord, the question of discord is whether he is entitled to this area as he claims. So, my lord, see that 197 passes the burden to the secretary. 197(2), my lord, the secretary of the department has to undertake an exercise and find out who was at fault. Then only then, my
So have you taken this exercise?
no, my lord, because this is under dispute whether he is entitled or not, my lord. Since, my lord, now that order, what I have placed, my lord, it was on his own, due to his own conduct, there was delay, my lord. And there was no,
That order was cleared in the earlier writ petition,
Yes, my lord.
saying that it is not a matter of concern whether
No,
he
my
has
lord.
2 wives or 1 wife.
That is the issue, my lord. That is instinctively connected to this because that delay, whatever has happened, that is due to the conduct of the petitioner himself. We had
No,
four-
what conduct?
because he had married 2, my lord.
That is why this court has clarified
Yes, my lord.
that since the petitioner is still
So-
alive,
Yes, my lord.
the issue of paying pension does not arise to the
Yes.
wife of the petitioner. Therefore, petitioner has to be paid, and therefore, if at all, if the petitioner dies, then after that only the issue.
That's
whether they will come.
that is a
That is
different issue
issue.
altogether, my
So
lord. But what
the-
happened?
The conduct
Yes.
of the petitioner is not under question now. It's your conduct.
No, my lord, the basic question, any delay under 197 has to be that this shows the conduct of petitioner because it was his conduct, there was a delay, my lord. My lord, interest,
No, my lord. It's not.
Let me make it clear, page 30.
Page 30, my
We
lord.
sought some clarification because he wants the name of both the wives to be included, which is not permissible under law. Page 30. That may be there was some delay. Because he wanted to name the both the wives.
My lord,
This
that
is all
picture
right.
doesn't arise now, my lord. Page 8, my lord. Can you see page 8 paragraph?
1 minute. This is a different issue. Petitioner is still alive.
that is settled, my lord. That is
Pension
settled.
will have to be paid to him
No,
only.
no, now he's not for pension, my lord. He seeks the interest on that payment,
That's why I'm saying
my lord.
seeking interest of the payment is in terms of section 197. correct?
197, yes, my lord.
Now, 197(2) says the secretary has to
Decide, my lord.
consider the matter.
Let him, my lord, let the secretary decide. Let the secretary take a call. Whose lapse was
Well,
this?
well, can I see
Either
the
he's
earlier order,
entitled
my
or
lord?
not, my lord. No, no,
Can
earlier
you
order
see
something
the
different, my lord. It's area-
early order, my lord? Okay,
Yes.
Honorable High Court, my lord.
Yes.
You are directed to, my lord, to submit compliance report.
It was
my lord.
not compliance report, my lords. It was a direction of his court that due to some areas were pending on him. The question before this court is whether he's entitled for interest or not.
Yes, my lord. Delay is, my lord.
No, what is this 1,04,800?
It was sanctioned, my lord. It was area. Area, my lord, when a person retires, my lord, there's some leave, my lord, leave
No,
administration.
this has been paid.
This has been paid, my lords. This has been paid because I have
You have received.
Is it, my lord? Only, my lord, the
Yes, receipt,
interest
my
part, my lord, I am demanding, my lord. Interest part, my lord.
So, my lord,
It is
that
their
is the
fault, my
question.
lord. I am, my lord, not getting
No.
the interest. part,
Page
my lord.
30 makes it clear.
Not my fault, my lord.
Here's
That's why
receipt.
at page 8, my lord. At page 8, can you see, my lord? Page 8, my lord. Can you see page 8, para 12? Para 12, my lord. May I read, my lord? That the petitioner wish to submit the respondent number 5 against resubmitted the pension papers of the petitioner to the chief conservator of forest legal by letter number so and so dated, as well as affidavit duly sworn in by both the wives of the petitioner declaring that the first wife has no objection due to her personal incapability, and she has no objection to record the name of the second wife, Mrs. Rehana Hazarika, wife of the petitioner, to get family pension benefits, etc. Accordingly, relevant documents were submitted for consideration of pension and other retirement benefits to the petitioner. But now there is no dispute, my lord. Only I am claiming the interest part, my lord.
So let the secretary take.
Let the secretary decide, my lords.
My lord.
But Mr.
Triple S Rahman.
Triple S Raman, let us counsel for the petition. Also heard Mr.
D. Gogoi, my lords.
D. Gogoi, Leonard,
Standing counsel forest, my lord.
1 minute.
One,
Standing counsel forest for respondents, 1,
3, and 5, my lords.
1, 3, and 5. Accountant General, Mr. B. Chakrabarty, Leonard, Standing Counsel, AG. Accountant General appears for respondent number 2, pension. And Mr. D. Bora, Leonard, Standing Counsel, Leonard Government Advocate, appears for the respondent number 4. Stop. Para. The petitioner, you are serving as
My lord, forest. My lord, ranger, my lord.
while serving as a forest ranger. Retired on 30/11/2018. Forest Ranger -1. Retired on 30/11/2018. Stop. Drafter, comma. The petitioner submitted his pension papers declaring the name of his two wives. Stop. Where's that page 8?
Page, my lord, 8.
No, page from the AG
30, my lord.
page.
30.
The respond number 2. Public Accountant General. To the Senior Accounts Officer. Raised in objection with regard to the second marriage of the petition. By projecting that the second marriage of the petitioner was in violation of Rule 26 within bracket 1 of the Assam Civil Services within bracket Conduct Rules 1965 by letter dated 28/10/2019. Stop. The said letter was addressed. The said letter dated 28/10/2019 was addressed to the Joint Secretary to the Governor of Assam, comma, Environment and Forest Department. Stop. As the petitioner was not paid his pension, comma, gratuity, comma, area TA bills and revised pay scale area. Petitioner approached this court by filing WBC number 348 of 2021. The said writ petition was disposed of by order dated 15/19/21. And the relevant portion which is under 8A. You have received all the pension,
My lord.
then you come for the petitioner. Para submits that consequent to the order is 15/19/2021. Passed in WBC number 348 of 2021. The petitioner has been paid his pension, comma, gratuity, comma, ARDA bills and revised pay scale area. However, by way of the present writ petition, petitioner is claiming for interest.
Interest, my lord.
He is claiming for interest under the provisions of Rule 197-A of the Assam Services within bracket Pension Rules 1969 for delayed payment of pensioner benefits to the petitioner. Stop. Para. Rule 19(7)(a) within bracket 2 of the Assam Service within the pension rules 1969. Or on top you say, rules of 1969 which of the rules of 1969 provides that every case of delayed payment of pension and gratuity shall be considered by the Secretary of the Department in respect of his employees and employees of its attached and subordinate officers. And where the Secretary of the Department is satisfied that the delay in payment of pension and gratuity was caused on account of administrative lapses, the Secretary of the Department shall sanction payment of interest with the concurrence of the Pension and Public Grievances Department at such rate as prescribed under sub-2 within bracket 6. Stop. Para. Accordingly, this writ petition is disposed of. Directing the secretary.
Secretary,
Is it the secretary?
Secretary, Environment and Forest. Department.
Consulting the, not the commissioner and secretary,
Secretary,
the secretary to the government of Assam, Environment and Forest Department to consider the case of the petitioner in terms of Rule 19.7-A within bracket 2 of the rules of 1969. And after comes a decision whether the petitioner is entitled to interest for delayed payment of pension and gratuity. Stop. Let such exercise be conducted and concluded within a period of 2 months, 2 months from the date of receipt of a copy of the order of this court. With the aforesaid observations and directions with petition to dispose.
Like,
Item 2, part third admission matter.
I think my lord has hired my learned friend. And
Yes, let's have a. recap.
yes.
Mark. There was an advertisement for the post of assistant professor Sanskrit in Nalbari College. Now,
Who is the advertisement?
advertisement, date of the advertisement is 4/7/2015. The advertisement itself is not annexed. That is not really relevant also, Madam. As soon as the advertisement was issued, and there was a writ petition preferred by the respondent number 6 here, that your lordship will find at page 48. And the operative portion is at page 53. Para 16. In view of the above, this court is of the view that the procedure adopted by the respondent authorities in following the office memorandum of 14/8/2015 for holding the selection process pursuant to the advertisement dated 4/7/2015 would be vitiated in as much as on the date of the advertisement, that is 4/7/2015, the earlier office memorandum dated 25/6/2012 was in force. Further, it has also to be taken note of that as per the affidavit filed by the Director of Higher Education, the vacancies that were advertised in the advertisement of 4/7/2015 were given the permission to be advertised on 25/6/2015. Therefore, at least on the said date, the vacancy had already arisen. In view of the above, the interview as well as the selection process held on 4/10/2015 is accordingly interfered and set aside. The respondent authorities may now proceed with the selection process pursuant to the advertisement dated so and so as per law. Now, my lord, the entire issue revolves around one mark
awarded to the respondent number 6 for experience. And what the whole crux. First, your lordship will kindly turn to page 26. I will take your lordship to the relevant OM as per which the mark is to be awarded, but the certificate that was submitted is this by the respondent number 6. Your lordship will kindly make a note of the date, 13/8/2011. This is to certify that Miss Chandana Deka, that is the respondent number 6 here, MA, MPhil, so and so, served as ad hoc lecturer. Your lordship will kindly note these words. Ad hoc lecturer in the Department of Sanskrit in MNC Balika Mahavidyalaya Nalbari during 2009-2010. The specific period is not mentioned. It just says that during 2009-10, she served as an ad hoc lecturer, and she has been serving as part-time lecturer for the session 2010-11 and 11-12. Both are purely temporary and terminable basis, etc. Now, naturally, a dispute arose that what is the period and in what capacity did you actually serve? Then what happened was this matter. A fresh certificate was issued, which your lordship will, originally your lordship will find at page 28. And a typed copy of that is at page 27. Your lordship may have the page 27. It is more legible. Your lordship will just again once more mark the date, 10/2/2015. And this is the certificate. This is to certify that Ms. MS Chandana Deka, so and so, has served as a teacher in Sanskrit in an ad hoc capacity during the session 2009-10 for 1 year. This time they specify the period. But she had served on ad hoc basis. Now, this certificate was issued purportedly on the basis of an application made by her, by the respondent number 6, which your lordship will find at page 33. This is the application in origin. With due respect, I inform you that I served as an ad hoc lecturer in the Department of Sanskrit in your college during 2009-10 and have been serving as part-time lecturer for the session 2010-11 and 11-12. Both are purely temporary and terminable basis. Now, I am in need of a certificate of an ad hoc lecturer during 2009-10 mentioning 1 year service, for which act of kindness I shall be grateful to you. She does not even mention that she actually served for 1 year, but she says that I need a certificate which says that I have served for 1 year. This is her application as submitted. Just below that, my lord, your lordship will kindly note the date on which it was received. It was received by the office of the principal on 17/3/2015. And your lordship will kindly see the date of the certificate. If the new certificate was issued 1 month and 7 days before the application was even submitted. 10/2/2015, this new certificate is already issued, and she had made this application only on 17/3/2015. There is apparently, my lord, some hanky-panky going on. In any case, my lord, even assuming we take this, the question is whether that 1 mark on the basis of this experience can be awarded or not. Now, your lordship will kindly come to the OM on the basis of which it is given. That your lordship will find page 2004. The lordship will allow me just one moment. Page 56. Page 56, this is what this honorable court in the earlier round of litigation said, that this OM has to be followed. And this OM says, your lordship will straight away turn to page, the OM starts at page 54. This is a OM of 25th of June 2012. The date is reflected at page 56. And your lordship will kindly, at page 56, the chart in the middle of the page, teaching experience 5 marks. Has my lord got it? Teaching experience 5 marks. Teaching experience, 1 mark for each completed year of service in an affiliated government degree college subject to maximum 5 marks. So it has to be 1 completed year of service for which 1 mark can be awarded. That is why original certificate did not mention 1 year. So she asked for another application, another certificate. Now the second certificate says 1 year, but on ad hoc basis. Now the question that arises for consideration is this OMR, page 29. And the type copy is at page 30. On 12th of October 2004, there is a policy decision taken by the government, and this is what it says. Subject, prohibition of engagement of teaching and non-teaching staff in deficit grants in aid college without any sanctioned posts. In continuation of this department's GM number so-and-so dated 17/7/2004, the following procedures, formalities are prescribed for banning the appointments of teaching, non-teaching staff against non-existent posts in deficit grants in aid colleges. Henceforth, no college under deficit grants in aid system shall engage any person for a teaching or non-teaching work where no sanctioned post exists for the purpose of filling up of vacant sanctioned posts. Existing government instruction guidelines will be responsible for any violation of the above sanctioned conditions. All members of the governing body or the college, including principal secretary of the college, will be responsible for any violation of the above mentioned conditions. The member secretaries of the respective colleges shall invariably submit reports of compliance to the above conditions twice in a year, and second report as on 1st April of the year, and the second report on 1st October of the year as a precondition for release of fund to such college by the state government. So therefore, there was an express ban on engagement of any teachers against non-sanctioned posts. Now, my lord, the engagement the engagement of the respondent number 6 was admittedly, if your lordship will kindly come to, there is an affidavit in reply filed by the petitioner against the affidavit filed by the respondents number 7 and 8, my lord. Would go on. Yes. Admitted by case 74. I'm sorry, my lord. The running page. Affidavit in reply from. My lord, your running page 144. This is an affidavit in reply filed by the petitioner against the affidavit filed by the respondent number 7 and 8. If your lordship kindly turns to the last page of that affidavit. We had sought for this information. And the college by which this certificate was issued. And these are all admitted, my lord. There's no dispute regarding these facts. I have the honor to state that there are no sanctioned posts of assistant professor in the Department of Sanskrit till date in MNC Balika Mahavidyalaya, Nalwar. Therefore, admittedly, her engagement was expressly illegal because there was an express ban. So, against experience gained purportedly against the non-sanctioned post illegally, whether she will be entitled to that 1 mark. If she is not entitled, I will be in. If your lordship holds that she is entitled, then I'll be out. Because there is a fractional difference in the marks obtained by me, and that is the whole issue. Now, my lord, what has been urged by the respondent number 6 is a judgment of this honorable court, which your lordship will find there is an IA file by the they want to say that in respect of another college, the same issue with regard to the same certificate had arisen. And this honorable court has held that she has worked for that particular point of time. However, there is a very interesting difference. This OM, which prohibits, which bans, firstly, my lord, I was not a party to that proceeding. And secondly, this OM of 2004, which banned all engagements against non-sanctioned posts, was never even placed in this proceeding. So naturally, this honorable court did not even have an occasion to deal with this aspect of them. So therefore, my lord, this judgment, although my lord, this is a submission I am making at the bar, my lord, that OM was not placed, naturally not considered. So therefore, whether she will be entitled to that 1 mark against the certificate on account of the OM was never an issue before this honorable court, and naturally not decided. So that issue your lordship will have to decide in this particular case. Although, well, I must admit that the fact that she had worked, registers were verified, etc., etc. So, and it was held that she did in fact work, and the attendance registers, etc., show that she had worked. So I am not even troubling your lordship on that aspect of the matter. The only issue that we are raising is on account of this OM of 2004, page 30, 29 and 30, her appointment becomes unauthorized, illegal, impermissible. Her engagement on ad hoc basis, and based on an illegal engagement, she cannot be entitled to that 1 mark for that particular year. I am not, if your lordship so desires, I can place those judgments. That a judgment is an authority for what it actually decides. In this particular judgment that has been placed reliance on by the respondent number 6, this issue never arose. So, if the need arises, I'll place those judgments. Otherwise, I'm not troubling your lordship. So, the entire issue is, in a nutshell, this: that she will, in my humble submission, my lord, she won't be entitled to that 1 mark because she was appointed against a non-sanctioned post, and that makes her engagement as ad hoc Sanskrit lecturer illegal. Hence, that award of that 1 mark is arbitrary. That is the limited mark.
My lord, I'm appearing for respondent number 6. Now, first of all, my lord, what is the basis for filing this writ petition, my lord? Is it the petitioner's case that I have got secured higher marks, she secured lesser marks? My lord, at what stage the proceeding is?
selection committee has not even given its recommendation to the governing body. Governing body is yet to refer the matter to the Director of Higher Education. Director of Higher Education is yet to approve it. It was at that stage an order of status quo was obtained. Is it not premature, my lord? We do not know. Everything we are proceeding on a realm of ifs and buts. Kindly take my affidavit, IA, my lord, which was at IA number 3505, which was treated as my affidavit in opposition. If your lordships will kindly come to page number 6 of my IA, my lord. The sentence starting with in compliance. In compliance of the aforesaid direction, has the lordship got it, my lord? At page 6 of the IA, yes. In compliance of the aforesaid direction of the Director, Higher Education, Assam, instructed Nalbari College authorities to proceed with selection process as per law. Accordingly, Academic Registrar, Guwahati University constituted a selection committee as approved by the Vice Chancellor. Pursuant thereto, the selection for filling up the post of Assistant Professor Sanskrit in Nalbari College on 25/4/22. However, the said selection process is not yet completed as the select list is yet to be placed before the governing body of the Nalbari College for its necessary approval. Once approval is accorded by the governing body, select list should be sent to Director, Higher Education Assam seeking final approval as per rule. It is only when the Director, Higher Education approves the select list, appointment can be made to the said post. Hence, in the humble understanding of the applicant, accompanying writ petition is premature in nature, as no cause of action violating any right of the opposite party writ petitioner has arisen. So this is my first preliminary submission, my lord. This writ petition is premature. Nobody knows who is selected, who is not selected, who secured what marks, whether I was given marks or not. Now, assuming, my lord, this 1 mark was given to me. Now let us test the argument of the petitioner. Now, what is their case? In the writ petition, the case has been structured on 2 bases. One, during the ban period, appointment was made. Therefore, the appointment is banned. That appointment order was never challenged by anybody, my lord. That, my lord, there has to be a declaration of law by a competent court of law that my appointment as ad hoc was wrong on account of XYZ reason. And to that, adjudication has to be done by a competent court of law, whereby, my lord, the consequences will follow. So that adjudication never took place because there was no challenge to my appointment by anybody. Fact of the matter is, my lord, I have served. Assuming it is an illegal appointment, then what happens? Assuming it is an illegal appointment, the other day I submitted, my lord, the doctrine of the de facto doctrine will save my experience. I'll place case clause on that. My lord, in an earlier litigation, this point was adjudicated, my lord. So that has become final. Supposing, my lord, my appointment as a lecturer is challenged by Mr. X, and the challenge, my lord, fails. Tomorrow, Y will come with another writ petition. It can't be, my lord. Once my appointment has been upheld, once, my lord, the Honorable Court rules that I worked for 1 year and I'm entitled to 1 mark, for me, my lord, it's final. Every time there will be no, otherwise, my lord, public policy demands what? The litigation must come to an end. Every day one cannot throw a challenge to my that experience part. Please come to that writ petition, my lord. In the IA we have annexed, page 25. Please come to page 26 for the facts. Para 4. My lord, this line of argument was, I could not perceive it, my lord.
In fact, there is a direct judgment of the Supreme Court. If an action is challenged on X ground, and if the challenge is negated, tomorrow on Y ground, that challenge cannot be made. The direct judgment of the Supreme Court. I'll get it.
The same party.
May not be by same party. PP exports case, I'll get it, my lord. Today, my appointment is challenged by Mr. X on XYZ ground. Court say negates the challenge. Tomorrow, my lord, B cannot come and challenge on the ground of X1, Y1, Z1. Supreme Court says it can't happen. And I'll get the judgment tomorrow, my lord. Please come to para 4. Applications were invited by advertisement dated 7/2/15 for filling up the aforesaid post of assistant professor in the Department of Sanskrit in ADP College, Nagaon. Petitioner and the respondent number 6 and many others responded to the said advertisement. On evaluation, the petitioner secured 68.43 marks and respondent number 6 secured 69.37 marks. And accordingly, the aforesaid resolution was taken as respondent number 6 had secured highest marks among the candidates. Coincidentally, my lord, in this writ petition, the challenge was won by Sandan Hazarika, my lord. There I was respondent number 6. So the difference of mark was less than 1. So therefore, this 1 mark thing was challenged. Please come to the next page, my lord. Please come to para 6, page 27. The dispute herein lies in respect of grant of 1 mark out of 4 marks. The principal of Mahendra Narayan Chaudhary Balika Vidyalaya Mahavidyalaya Nalbari had issued a certificate dated 10/2/15 certifying that respondent number 6 had served for 1 year as ad hoc teacher in Sanskrit in college session 2009-2010. This certificate was doubted and contention advances that respondent number 6 did not render service for 1 year in the aforesaid Mahendra Narayan Chaudhary Balika Vidyalaya. If the aforesaid certificate is disbelieved, the marks obtained by respondent number 6 would come down to 68.37. In that scenario, the petitioner would emerge as the candidate who had secured highest marks and thus would be entitled to be recommended for appointment. So this is the factual background, my lord. Then my lord will kindly come to page number 30. Sorry, page 29. Page 29, para 14, 15, and 16. The question that has emerged for consideration is whether respondent number 6 was sought to be given undue benefit on account of experience by respondent number 7, demonstrated by certificate issued by him in favor. The one at page 27, my lord, of the writ petition, that at February 15 certificate. It is seen that respondent number 6 was appointed not on the basis of resolution adopted by the governing body of college, but by principal of the college on the strength of a resolution authorizing the principal to appoint a lecturer on need-based basis. If the college authorities are unable to produce the appointment order issued in favor of 6 or joining report, the respondent cannot be penalized. The question is whether there is any acceptable record which will persuade the court to take a view that respondent number 6 had served for 1 year in the college during the relevant period. And acquittance role will enable the court to come to such a conclusion if such acquittance role generates confidence in the mind of the court that it is a genuine record. I have gone through the acquittance role. It is a bound register in respect of the period starting from the year 2000 to 2013, showing disbursement of salary on month-to-month basis. The acquittance role as produced by respondent number 7 is an old book and appears to be genuine document. The name of the respondent number 6 is not always the last name in the list of the staff, which should have been the case if the name of the respondent number 6 was sought to be illegally entered in the acquittance roll at a later date. The acquittance roll had chronologically reflected the payment of salary to the incumbent staff, and the respondent number 6 had drawn salary for the first time on 10/9/2009. Her name appears at the serial number 4 below her name, May to August, is indicated and salary paid to her is 5,500. In the subsequent months, Respondent number 6 was paid 2,500. It will be difficult to say on what basis the amount of so and so was paid. The last payment made to respondent number 6 was 6/10/2010, and acquittance roll shows that payment was made for the month of September 2010. Here also name of the respondent number 6 was not the last one, which might have indicated that her name is inserted at a later date. She was placed at serial number 27 of the list, which continued up to 45 in seriatim. So these are the materials which were taken note of by the learned single judge in an earlier occasion to find out the veracity of the stand I took, my lord, before the court on that day. Now, para 20. It is already indicated that the respondent number 6 had for the first time drawn salary in the month of September. Even if her service is reckoned from the month of August 2009, she had completed more than 1 year service as he continued to serve till the month of September 2010. Therefore, certificate dated 10/2/15 issued by principal is a document based on original record which can be acted upon for award of marks towards experience. Therefore, grant of 1 mark on the basis of the aforesaid certificate produced by respondent number 6 cannot be held to be illegal or arbitrary. Resultantly, I am of the considered opinion that no interference is called for. Now, my lord, as far as the certificate is concerned, as far as the factum of that I served for more than 1 year, that was taken off judicial notice by this honorable court, and a challenge in that regard was negated. Now the question is, my lord, today you want to put in a challenge on the ground that there was a ban period, therefore I could not have been appointed. My lord, my answer is twofold to that. One, your challenge does not even deserve consideration because I am not subject to face challenge at the behest of X, Y, and Z, my lord, every time a challenge is made. I'll place the judgment tomorrow, my lord. Number 2, now assuming, my lord, my appointment is banned. Now, will my experience evaporate in thin air? No. That's the legal principle. That principle is called, my lord, de facto doctrine. Let me place the judgment. My lord, there is a division bench judgment of our High Court, my lord, where this view was taken. Now, my lord will kindly have 2022 5 GLT 324. Please come to, my lord, para 29. My lord, para 29. 2022 5 GLT 324. Dilip Kumar Sharma versus State of Assam. My lord will kindly come to page 6, para 29. Para 29 at page 6, my lord.
Yes.
Kindly towards the below. Fourthly, the appellant has a lordship got it, my lord. Fourthly.
Yes.
Fourthly, the appellant has taken a new plea at this appellate stage contending that writ petitioner Ibrahim Ali is not eligible to be appointed as principal of the said school, inasmuch as he himself does not possess the requisite qualification of 15 years of service as a postgraduate teacher. So, my lord, contention was that he does not have even the requisite qualification. So, my lord, his appointment is bad. It has been contended that the writ petitioner Ibrahim Ali had entered service through backdoor and he was regularly appointed without going through normal process of appointment, and as such, his alleged 15 years of service cannot be considered to be regular service within the meaning of the rules. That was the challenge. Now, my lord will kindly come to page 8. Please come to para 34.
Yes.
Page 8, para 34. As regards the contention raised before us, that the writ petitioner Ibrahim Ali himself does not have the requisite qualification for applying to the post of principal of the said school, since on the last date of submission of application, he did not fulfill the required 15 years of experience as a postgraduate teacher, as the document annexed by him in the writ petition reveal that the service of the petitioner was regularized on 23/3/2003. Thus, on the last date of submission of the application form, the writ petitioner has completed only 13 years of service. We are not impressed with the said plea. Further, the said regularization was not followed by following the due process of law. Okay, please come to para 36. The basis for such a plea is that writ petitioner Ibrahim Ali had entered into service through backdoor and his service was not regularized in terms of the relevant rule, and as such, his past service cannot be counted, and as such, he did not have 15 years of teaching experience as a postgraduate teacher. However, on perusal of the relevant rule does not indicate that the person has to have service experience on regular basis only. What rule provides is that candidate must have teaching experience without mentioning whether such experience should be regular experience or not. Well, that experience is experience. Even Supreme Asim Kumar Bose's case, Supreme Court also said the same thing, my lord. I'll come to that. Now, please come to the subpara. Nowhere it is mentioned that only experience gained after regular appointment shall be considered, and experience while gained on ad hoc or such nature cannot be considered. Under these circumstances, we do not find any merit in this plea. For the reasons above, we are of the view that decision relied upon by the learned senior counsel for the appellant are not applicable. Then, my lord, it was also sought to be urged before us that since regularization of writ petitioner Ibrahim Ali was dehorsed the rules, the experience cannot be. This is very important for our case. Because here, my lord, my appointment was in violation of that OM. And that OM, my lord, is an executive instruction, whether it can be enforced in a court of law. I'll place judgments on that also. That's an executive instruction. Does it have any statutory force? It was sought to be urged before us that since regularization of the writ petitioner, Ibrahim Ali has dehorsed the rule, his experience cannot be counted while computing his eligibility. We are of the opinion, since experience required under the rule in the present case does not pertain to nature of appointment, the above cited decisions are not applicable. So, my lord, even if your appointment is wrong, if you have gained experience, that can be counted. Then, my lord, will kindly come to that Asim Kumar Bose, that is Robert. My lord, 1983, 1 SCC 345.
Yes.
My lord, will kindly come to para 29. At page 361.
Yes.
It is necessary to emphasize that the recruitment rules nowhere provide that teaching experience gained by a specialist in teaching hospital in the capacity of associate professor ex officio shall not count towards requisite teaching experience. There is no provision made in the rule that teaching experience must be gained on a regular appointment. There is hardly any difference so far as teaching experience is concerned, whether it is acquired on regular appointment or as a specialist in a teaching hospital with ex officio designation. As the statutory rule do not provide that the teaching experience gained in an ex officio capacity shall not count towards teaching experience, requisite teaching experience, the teaching experience gained by the appellant while holding the post of radiologist cum associate professor of radiology ex officio in the Irvine Hospital cannot be ignored in determining his eligibility for appointment as professor of radiology in Maulana Azad Medical College. So, my lord, the Supreme Court was clearly of the view, when it comes to counting of experience, my lord, it does not matter whether you acquired that experience by working in a regular post or an irregular post and illegal post. Experience is experience. It cannot be wiped out, my lord. Now, please come to the writ petition for a moment, my lord. Let us see that requirement. Page 53, my lord. 6, sorry. Page 56, teaching experience 5 marks. 1 mark for each completed year of service. Now, if it was the intention of the my lord authority that only service obtained in a regular appointment would be counted towards experience, then they would have expressly said so. This is service. You know, the term service denotes both regular and my lord, ad hoc or whatever it is. Experience is experience. It could have said, it could have expressly said regular service. Therefore, the fact that, my lord, the word regular is missing, the intention is very clear of the authority. Any experience will come. And these are the, I think the preponderance of the judicial view seems to be that. Then, my lord, on the de facto doctrine, I'll place the judgment, my lord, 1991, 1 SCC 319. 1991, 1 SCC 319, para 5 and 6. Central Bank of India versus Barnard, C. Barnard.
1991.
Yes. 1991, 1 SCC 319. Again.
Yes,
Yes.
Central Bank.
Yes. My lord will kindly come to page 324, para 5. My lord will
Yes.
kindly come to the last 2 sentences towards the bottom, placitum I. According to him. Has your lordship got it?
Yes.
According to him, he continued to function as inquiry officer de facto, and hence his actions and decisions were saved. The de facto doctrine has 2 requirements, namely the possession of the office and the performance of the duties attached thereto, color of title, that is apparent right to the office, and acquiescence in possession thereof by the public. According to this doctrine, acts of officers de facto performed within the sphere of their assumed official authority in the interest of public or third parties and not for their own interest are generally held valid and binding as if they were performed de jure. When, my lord, this performance is for my lord in public interest, when I teach, my lord, I serve a public interest. So it will be presumed that it was I performed it de jure. That's illegally. So to say that there was a ban on appointment, therefore my appointment was illegal, therefore my teaching experience will evaporate, is preposterous, my lord. At least our jurisprudence do not admit of any such proposition. Then my lord will kindly come to placitum F. Between placitum F and Z, the sentence starting with, my lord, the example, the Allahabad High Court, has your lordship got it, my lord? Yes. The Allahabad High Court in Jai Kumar versus State upheld the judgment of district judge whose appointments were later struck down by the court on the principle that acts of the officers de facto are not to be questioned because of want of legal authority, except by some direct proceeding instituted for the purpose by the state or by someone claiming office de jure. Tomorrow, my lord, if a district judge passes some orders, though his appointment are illegal, those orders do not evaporate, those remains. Well, otherwise, my lord, because, my lord, end of the day, there has to be an exception to every rule. Well, why in the case of bias, prejudice, the rule of the doctrine of necessity has been evolved? These are the, my lord, instances where exceptions are to be carved out. Supposing, my lord, there are 3, in a particular high court, there are 4 judges. A particular matter cannot be taken up because all the judges. Doctrine of necessity says no. In an appropriate case, even then one can take up the matter. That will not invalidate the judgment. So, my lord, therefore, the legal principles are well demarcated. It's absolutely clear, my lord. This ban on appointment will not do any. Then, my lord, will kindly go up to next para. Para 6.
Yes.
In our view, the submission of Sri Swenso based on the de facto doctrine is clearly misconceived. Mr. Sri U.B. Menon can hardly be described as a person occupying or being in possession of an office to which certain duties affecting members of general public can be said to be attached. The de facto doctrine, as explained earlier, envisages that acts performed de facto by officers within the scope of their assumed official authority are to be regarded as binding as if they were performed by officers de jure. While the de facto doctrine says official acts done by an officer whose appointment is found to be defective, the private parties to a litigation are precluded from challenging the appointment in any collateral proceeding. But the doctrine does not come to rescue of an intruder or usurper or a total stranger to the office. Obviously, the doctrine can have no application to the case of a person who is not the holder of the office, but merely bank employee, for that matter, an ex-employee. We therefore see no merit in this context. So, my lord, as far as an usurper of an office is concerned, his acts, though performed de facto, my lord, it will be presumed to be de jure. Therefore, the rights emanating from that will continue to be binding. And the third party cannot bring in any collateral proceeding to challenge that. So therefore, my lord, legal principles are very clear. Number one, this 1 mark business was already settled by this honorable court in another issue. The same very certificate, same 1 mark. Here, of course, the facts are not clear because selection body minutes are yet to be forwarded to the, my lord, governing body. Now, finally, on that, my lord, on the legal efficacy of that OM, saying ban on recruitment. What it is, my lord? It is an executive order. Please come to my lord, para 20 of the judgment, 2007, 8 SCC 212. 2007, 8 SCC 212, para 20. My lord will kindly come to
1 minute.
yes. Lord, before your lordship takes the judgment, if your lordship would kindly come to page 30 of the writ petition, the OM, which they would like to, my lord, enforce.
Yes.
Office memorandum, prohibition of engagement of teaching and non-teaching staff in deficit grant in college without any sanction post. Now, my lord, this is not expressly done in the name of the governor. My lord will kindly have Article 166(1) for a moment. All executive action of the government of a state shall be expressed to be taken in the name of the governor. Orders and other instruments made and executed in the name of the governor shall be authenticated in such manner as may be specified in the rules to be made by the governor and the validity of an order or instrument which is so authenticated shall not be called in question on the ground that it is not an order or instrument made or executed by the government. So my lord, whenever any executive order is issued, it is required to be expressed in the name of the governor. Not doing so, my lord, consequences are enough, judgments are there. So now my lord will kindly come to the judgment. So there is no dispute that it is an executive order. Now let us see, my lord, what is the enforceability value of such an OM. Please come to para 20 at page 221.
Yes.
It is well settled that the central government or the state government can give administrative instruction to its service how to act in certain circumstances. But that will not make such instruction statutory rule which are justiciable in certain circumstances. In order that such executive instructions have the force of statutory rule, it must be shown that they have been issued either under the authority conferred on the government by some statute or under some provision of the Constitution providing therefore. Therefore, even if there has been any breach of such executive instruction, that does not confer any right on a member of the public to ask for a writ against the government by petition under Article 226 of the Constitution of India. So this, for violation of that, my lord OM, a citizen or a person cannot come before a lordship and say there is a violation, give a judgment in my favor. It is not even maintainable. So in that view of the matter, what is there in this case, my lord? Unnecessarily, my lord, this entire selection has been held up for the last more than 1 year. First, it is premature. Secondly, my lord, the issue is covered by judgment. And thirdly, I have already mentioned these 4 points back. If their case is they want to enforce this OM, then my lord, they are not entitled to any relief. If their case is that experience cannot be, it is already decided.
Yes.
So therefore, my humble submission is, my lord, the interim order should be vacated and writ petition should be dismissed. There's nothing, my lord. As such, my lord, this is really premature. Nobody knows what selection committee has taken note of. They are proceeding on the basis. Assuming, my lord, even if their assumption is taken to be correct, even then, my lord, I don't think there is any merit in the writ petition. That is my humble submission.
You said you wanted to place some judgments tomorrow.
No, my lord, only lordship may reserve it for order or whatever. On the judgment of the point, my lord, a particular cause of action, it's not that today somebody will file, tomorrow somebody will file. That cannot be. Because the point was sought to be taken that, my lord, in the earlier case, the ban part was not there. The ban part I have shown already, my lord. You can't even come for enforcing that. Only that judgment I'll place tomorrow, my lord. Hey, Punjabur and case.
My lord, the submissions that
Other sides? Official, you are respondent? Seven and eight.
बाबा नहीं बटे ना कोई दिया जैसे इलेक्शन हो भाई नहीं कोई दिया
Higher education?
with the lordship's kind permission can I take deeply.
under the submissions that have been advanced are, as I could understand, fourfold. First submission.
1 minute, let the other side completes. then we can continue. Who appears for higher education? Governing body, none.
Sorry, I missed the case.
Hmm?
I have some time to bring the file, my lord. I need some time to bring the file, my lord. I have missed the case, my lord.
You want some time to bring the file?
Yes, my lord. Outside the court, my lord. I'm just coming, my lord.
Yes, Mr. Chowdhury, then you bring your file.
My lord, 4 points have been taken. First, it has been urged that the petition is premature. As your lordship has noted, the only point that we have urged is award of that 1 mark. And if your lordship will kindly come to the running page, there is an affidavit in opposition filed by the respondent numbers 3 to 5. Nalbari College. The running page, it starts at 73, man, page 73.
Yes.
If your lordship will kindly come to page 79. This is the college and this is the specific stand. At the very top, page 79, this is a continuation of paragraph 6. It's a very long paragraph. I'm just reading out the relevant portion. On 25/4/2022, the selection committee thus concluded the selection procedure. After penning down their allotted marks to all the candidates, pursuant to which the consolidated statement of marks allotted to all the candidates for the post of assistant professor in the Department of Sanskrit, Nalbari College, Nalbari was prepared, in which the respondent number 6 secured the highest marks, 69.37, and the petitioner secured 68.65. As such, the selection committee prepared its report in which the respondent number 6 was declared as selected candidate for the concerned post. As I was pointing out to your lordship, that difference is of less than 1 mark. They have awarded that 1 mark and they have declared the respondent number 6 to have been selected. So, merely because it has not gone to the director for approval, the decision has already been taken. They have awarded that 1 mark and they have declared him to be the selected candidate because she has secured the highest mark. This is the challenge. So therefore, my lord, to contend that it is premature, perhaps that contention may not be available. Now, the second argument is entirely on the basis of the earlier judgment passed by my Lord Justice Goswami, A.K. Goswami as he then was. If your lordship will kindly come to the judgment, your lordship takes up the IA for a moment.
Yes.
There, the judgment starts at page 25. Your lordship will find I was never a party to this proceeding. At page 25. The second difference your lordship will find is in the cause title itself, that the college in which this election took place was a completely different college altogether. This is Anandaram Dhekial Phukan College. Page 25. That itself will indicate the selection was for a different college. I was never a party to the proceedings. And most importantly, the issue before the Honorable Court in that particular case was whether she has actually worked or not. We are admitting that position because of this judgment. We are not challenging it on the basis of that point. We are admitting that she has worked on ad hoc basis. We are not putting any challenge on the basis of her, whether she has actually worked or not. The challenge is, assuming you have worked on the basis of that OM, will you be entitled to that 1 mark? And that point was neither urged nor placed and naturally not considered. On that, my lord, I would like to place a few judgments. What is the precedential value of a judgment? The first judgment, all these judgments I had placed on the last occasion, it should be there. The first judgment I would like to place reliance on is 2003 volume 7 SCC 197.
1 minute. Two thousand?
2003 volume 7 SCC 197.
Yes.
Your lordship may kindly turn to para 23, my lord, straight away.
Yes.
So far as Nagesha case relied upon by the claimant is concerned, it is only to be noted that the decision does not indicate the basis for fixing of the quantum as a lump sum was fixed by the court. The decision ordinarily is a decision on the case before the court, while the principle underlying the decision would be binding as a precedent in a case which comes up for decision subsequently. Therefore, while applying the decision to a later case, the court dealing with it should carefully try to ascertain the principle laid down by the previous decision. A decision often takes its color from the question involved in the case in which it is rendered. The scope and authority of a precedent should never be expanded unnecessarily beyond the needs of a given situation. The only thing binding as an authority upon a subsequent judge is the principle upon which the case was decided. Statements which are not part of the ratio decidendi are distinguished as obiter dicta and are not authoritative. The task of finding the principle is fraught with difficulty, as without an investigation into the facts, it cannot be assumed whether a similar direction must or ought to be made as a measure of social justice. Precedents sub silentio and without argument are of no moment. I am laying emphasis on this sentence. Here is a case. It is out and out sub silentio because the OM was never even placed. Mere casual expressions carry no weight at all, nor every passing expression of a judge, however eminent, can be treated as an ex cathedra statement having the weight of authority. So, in my respectful submission, my lord, the question, the fact that she actually worked on ad hoc basis is, we are not disputing for a moment. Having worked, whether she will be entitled to 1 mark is the question that arises for consideration in this case. Therefore, the earlier judgment cannot come to their rescue to thwart the challenge made in this particular case. Similar is the, I am not placing this, my lord, I am just giving the citation, 2006, volume 6, SCC 366. Here also the apex court similarly has said that a judgment is an authority for what it actually decides. Now, this is a judgment I would like to place, my lord. Here the Supreme Court has said that even a little difference in facts can take away the precedential value of an earlier judgment. This is 2003, volume 2, SCC 111. This judgment was also placed, my lord, should be there in the records. 2003, volume 2.
Yes.
Volume 2, SCC 111, para 59. Has my lord got it?
Para?
Para is 59, my lord. It's a very short paragraph. A decision, as is well known, is an authority for which it is decided and not what can be logically deduced therefrom. It is also well settled that a little difference in facts or additional facts may make a lot of difference in the precedential value of a decision. Here is a case, my lord. This fact of the OM was not even before the court. This is a completely new fact before your lord. So whether that 1 mark she will be entitled on the basis of the fact that she was an illegal appointee. That question was never a question before the honorable court, my lord, in that case. Now, my lord, this is another judgment where the apex court, may I place one short paragraph? 2002, volume 3 SCC 496. This also should be there.
Yes.
2002, volume 3 SCC 496. The paragraph I am relying on is para 19.
Yes.
Courts should not place reliance on decisions without discussing as to how the factual situation fits in with the fact situation of the decision on which reliance is placed. Observations of courts are not to be read as Euclid's theorems, nor as provisions of the statute. These observations must be read in the context in which they appear. Judgments of courts are not to be construed as statutes. To interpret words, phrases, provisions of a statute, it may become necessary for judges to embark upon lengthy discussions, but they do not interpret, to explain and to define. Judges interpret statutes, they do not interpret judgments. They interpret words of statutes. Their words are not to be interpreted as statutes. What it really says is, if the factual situation does not fit in, unnecessarily reliance should not be placed on it. Here is a case, my lord, that judgment has no applicability. We are not disputing that she has worked. She has worked, but what is the status of that work rendered by? If it is illegal, and there are 2 judgments that my learned friend has placed, your lordship has noted. One judgment that was placed was 2022 volume 5 GLT, and immediately thereafter 1983 1 SCC. There is a very fine difference. Both these judgments, the question was whether it was regular service or service rendered on ad hoc basis or temporary basis. Here, it is illegal. It is not irregular. Since there was a blanket ban on all appointments against non-sanctioned posts, it was illegal. Had someone challenged it, the question that was posed is, no one challenged it. If can I challenge it because I don't have a cause of action? I don't have any grievance against her ad hoc appointment in Nalbari College. There's no question of me challenging it. I will challenge it collaterally when the occasion has now arisen that you are awarding a mark to her to which she is not entitled. So therefore, now that the cause of action has arisen, I have come before your lordship. Earlier, I was never interested whether she was working on ad hoc basis in Nalbari College or Gwalpara College or wherever. I have to have a cause of action to challenge someone's appointment. Here the question is, you have rendered service, no doubt. You have rendered service on ad hoc basis, no doubt. Factually, you have done so. That has been upheld by this honorable court. The question before your lordship is, having done so, would you be entitled to the mark? We are not factually disputing that she has worked. Now, my lord, very interestingly, the de facto doctrine has been pressed into service. I was aghast. What does de facto doctrine say? De facto doctrine says that, assuming the same example I am giving one, a district judge is appointed. For 2 years, he continues to render service. Subsequently, his appointment is found to be illegal and he is removed from that post. The judgments he has delivered will remain. No one can question those judgments. But the factum of illegality of the appointment remains. The fact that he was illegally appointed and that he has been thrown out of the job, that will remain. Here also, assuming she has rendered service as a lecturer, assuming she has corrected some examination answer scripts, she has awarded marks to some students, those marks will remain. But the factum of her illegal appointment continues. That illegality will continue. That is de facto doctrine. My lord, in fact, de facto doctrine, that's central bank judgment has been placed. De facto doctrine in India started with that Rangaraju case, my lord. May I place that? This is Gokaraju Rangaraju, 1981 Supreme Court. This judgment, in fact, very beautifully explains what the de facto doctrine is. And in fact, this is in the context of a judge whose appointment was found to be illegal. May I first place paragraph 1?
Yes.
De facto doctrine does not deal with the legality or illegality of the appointment itself. It only deals with the actions the person has taken during the course of his continuance in the post. What is the effect, para 1, Manu? What is the effect of the declaration by the Supreme Court that the appointment of an additional sessions judge was invalid on judgments pronounced by the judge prior to such declaration is the question for consideration in these criminal appeals. So what will happen to the judgments passed by him? That is de facto doctrine. Now, if your lordship will kindly come to para 4.
Yes.
We are unable to agree with the submissions of the learned counsel for the appellants. The doctrine is now well established that the acts of the officers de facto performed by them within the scope of their assumed official authority in the interest of the public or third persons and not for their own benefit are generally as valid and binding as if they were the acts of officers de jure. As one of us had occasion to point out earlier, the doctrine is founded on good sense, sound policy, and practical experience. It is aimed at the prevention of public and private mischief and the protection of public and private interest. It avoids endless confusion and needless chaos. An illegal appointment may be set aside and a proper appointment may be made, but the acts of those who hold office de facto are not so easily undone and may have lasting repercussions and confusing sequels if attempted to be undone. Hence the de facto doctrine. The very logic behind the de facto doctrine is a person might have been appointed wrongly. He continues for a period of 2 years. During that period of 2 years, he has rendered judgments, assuming it's a district judge or some judicial officer, or if it is some other officer, he must have done various official acts. All those acts will not get nullified, but the illegality in the appointment continues. Now, if your lordship will come to para 17, para 17 and 18, make the position further clear. Till, in fact, from para 8 onwards, rather 5 onwards, the evolution of the law has been discussed in detail, and para 17 and 18 are the conclusions. A judge de facto, therefore, is one who is not a mere intruder or usurper, but one who holds office under color of authority. If I may pause here for a moment, Malu. Who is not a mere intruder or usurper? Had someone questioned it, if your lordship sees the language of the OM, the government is saying that every 6 months you submit compliance report. Had it come to the notice of the government, she would have been thrown out. So therefore, here is a case who is not only an intruder, she is also a usurper of the office. A judge de facto, therefore, is one who is not a mere intruder or usurper, but one who holds office under color of lawful authority. Just to pause here for a moment, Mal, to give a clearer example. Assuming, again taking the example of a district judge, there is a selection held. In the selection process, there are some irregularities committed, but the factum of the selection is not in dispute. After that, he or she is appointed. And 2 years down the line, it is found that in the selection process, there were some irregularities. Either the appointing authority may take a decision that we will terminate the appointment, or it comes before your lordships and your lordships strike it down. In two ways, it can be terminated. There, it will be under lawful authority because rightly or wrongly, there was some selection held. But bringing that analogy to this case, there was a ban. So the entry into the office itself is an intrusion, is an usurpation of the office. That is the subtle difference, my lord. And may I read it once again, my lord? A judge de facto, therefore, is one who is not a mere intruder or usurper, but one who holds office under color of authority. Though his appointment is defective and may later found to be defective. Whatever be the defect of his title to the office, judgments pronounced by him and acts done by him when he was clothed with the powers and functions of the office, albeit unlawfully, have the same efficacy as judgments pronounced and acts done by a judge de jure. Such is the de facto doctrine, born of necessity and public policy, to prevent needless confusion and endless mischief. There is yet another rule, also based on public policy. The defective appointment of a de facto judge may be questioned directly in a proceeding to which he be a party, but it cannot be permitted to be questioned in a litigation between two private litigants, a litigation which is of no concern or consequence to the judge except as a judge. Pausing here for a moment, Marad. By showing the central bank judgment, an argument was sought to be advanced that it cannot be questioned in a collateral proceeding. What that collateral proceeding meant was this. If your lordship reads this sentence once again, the position will be very clear. The defective appointment of a de facto judge may be questioned directly in a proceeding to which he be a party, but it cannot be permitted to be questioned in a litigation between two private litigants, a litigation which is of no concern or consequence to the judge except as a judge. Pausing here for a moment. What it means is, assuming the judge has passed a judgment which affects two private parties, Mr. X and Mr. Y. Neither Mr. X nor Mr. Y can file an appeal saying that the appointment of the judge was illegal. But if that judge is directly involved in the proceeding, where his appointment itself is in question, it certainly can be put to challenge. Now, the Apex Court further illustrates, two litigants litigating their private titles cannot be permitted to bring in issue and litigate upon the title of a judge in his office. Otherwise, as soon as a judge pronounces a judgment, a litigation may be commenced for a declaration that the judgment is void because the judge is no judge. A judge's title to his office cannot be brought into jeopardy in that fashion. Hence, the rule against collateral attack on validity of judicial appointments. To question a judge's appointment in an appeal against his judgment is, of course, such a collateral attack. So what is collateral has been explained in this judgment. We do not agree with the submission of the learned counsel that the de facto doctrine is subject to the limitation that the defect in the title of the judge to the office should not be one traceable to the violation of the constitutional provision. The contravention of a constitutional provision may invalidate an appointment, but we are not concerned with that. We are concerned with the effect of the invalidation upon the acts done by the judge whose appointment has been invalidated. The de facto doctrine saves such acts. So, what it saves, de facto doctrine, what it saves is the actions taken by the person while he was in office. It does not save the appointment itself. So therefore, my lord, the de facto doctrine, in my humble understanding and in my humble submission, has no application whatsoever in this case. The illegality will not go away. Whatever actions she has taken, she might have corrected answer scripts, she might have awarded marks to some students. All those actions will be saved. But the illegality in her appointment cannot be saved. Now, the last argument that was advanced was that the OM has not been issued in the name of the government. I am with utmost humility, my lord. There are several judgments of the Supreme Court which say that Article 166 is directory, not mandatory. All actions taken by the state are deemed to have been taken in the name of the government. If your lordship peruses the rules of executive business, the lordship will find that all or any action taken by the state are deemed to have been taken in the name of the government. There are hundreds and thousands of orders and notifications your lordship will find where it is not mentioned that it is done in the name of the government. Hundreds and thousands every day. It is deemed to have been done in the name of the government. It's an executive act. So therefore, my lord, looked at from whatever angle, and just to place that OM once again, my lord, if your lordship sees the OM, language of the OM, it was not merely a ban. The subject itself makes the position very clear. Prohibition of engagement of teaching and non-teaching staff in deficit grants in a college without any sanctioned posts. In continuation of this department so-and-so, dated so-and-so, the following procedures, formalities are prescribed for banning the appointments of teaching, non-teaching staff against non-existent posts in deficit grants in aid colleges. Henceforth, no college under the deficit grants in aid system shall engage, the word is engage, which includes ad hoc engagement, temporary engagement, any person for a teaching or non-teaching work where no sanctioned post exists for the purpose. And thereafter, at para 4, the government says the government is monitoring. And here is a college which does not comply with para 4 and engages her. Had it come to the notice, she should have been thrown out immediately. The government is asking for compliance reports every 6 months. So therefore, my lord, in my respectful submission, she, on the, my lord, submission with respect to de facto doctrine, the argument is twofold. Firstly, in fact, my lord, the same judgment that my learned friend placed, the central bank, if your lordship will have para 6 for a moment. This is central bank is 91(1) SSC. I will just, my respected senior friend had placed paragraphs 5 and 6. I will just lay emphasis on one sentence in para 6. Your lordship will find in para 6, line about 5 from bottom. There is a sentence starting, but this doctrine. But the doctrine does not come to the rescue of an intruder or usurper or a total stranger to the office. So even the acts cannot be saved if you are an intruder or if you are a usurper of the office. So here is a case, out and out the respondent number 6 was a usurper of office because there was a blanket ban. And assuming she was not, the actions taken by her can be saved. The illegality in the appointment cannot be saved. And if that be so, if it was an illegal appointment, whether that 1 mark can be awarded to her, and whether your lordships will allow such illegality to be perpetrated. That is the question before your lord. In my respectful submission, my lord, on each of these counts, assuming, my lord, they want to say that it is premature, your lordship will make a observation that they will look into the applicability of the OM, and when the director approves, He will look into the applicability or otherwise of the OF. That is my alternative argument. I am saying my first argument is that it is not premature because the mark has already been awarded and it has been declared that she is the selected candidate. So therefore it is not premature. But however, in the event your lordship feels that let it go to the director, let the director decide. Your lordship will make an observation that the director has to look into, because this aspect is a question that has to be answered either by your lordships during the course of adjudication of this case or by the director when he is examining. So that is my respectful submission.
Higher education.
Can I be excused? Deeply obliged.
Well, higher education doesn't have much role, my lord, in this case, as the director is yet to take a decision, and I'll also take adopt the same argument, my lord, regarding maintainability of this my lord, case. And as my learned senior has already, my lord, submitted that the matter may be, my lord, remanded to the director, directing the petitioner as well as the private respondent, my lord, also to take a decision. Because those are the, my lord, dispute of factual disputes, my lord.
Where was that provision that the director has to take a phone?
The judgment, my lord.
Rules provide that. Which rule was that?
My lord, the appointing authority is director, my lord. So director has to take a call. The selection committee selected the candidate, one candidate, my lord, that is the name of that candidate is sent to director for approval, my lord.
Heard I Chowdhury, Learned Senior Counsel. Assisted by
My lord, as Hazarika.
S. Hazarika, Learned Counsel for the petition. Stop. Also heard Mr.
As the
S. Das,
Higher education.
Standing Council Higher Education. For the respondents, 1 and 2. 1 and 2. Anybody, governing body?
I'm for the earlier comment. E4 and 5 your lordship. I think I'm ready to open the state.
Who?
E for number.
Mr. B. Bharadwaj.
He appears for respondent number 3, 4, and 5.
Learned Counsel for the respondents, 3, 4, and 5. Mr. K. N. Jowdy, Learned Senior Counsel, assisted by Mr. G. Bhatwari. For the respondent number 6, 7, and 8. And Mr. M. Sharma, Learned Counsel for the respondent 7 and 8. You are adopting the submission of Mr. K. N. Jowdy.
In fact, the lordship, I am one party in the matter, but my experience is that I am not all the selection process as of the matter. In any case, I will adopt the submission.
Hearing concluded, judgment is. Bhatwari, the judgment which Mrs. K.
Tomorrow morning, I will hand it over for that. Like, just point indicating paper. The earliest intent of honorable justice. And the motion will kindly peruse para right there, because the principal had the offer. Can I just read it, a small para? Para 9 of the earlier judgment is annexed to our IA matter. At page 27. Para 9.
Yes.
Sri Swancho, Learned Counsel for the respondent number 7, has submitted that by resolution number 2 dated 2/8/2009, the principal was authorized to appoint ad hoc lecturer on need-based basis. So there was a necessity, my lord. He placed before the court the resolution book for the year so and so, from dated so and so, which contains the aforesaid resolution. I have perused the same. The court, the honorable court perused the same, my lord. He also produced before the court the acquaintance roll for the year 2000 to 2013 to highlight that the respondent number 6 was drawing salary for the period of 1 year, and therefore it was not correct as alleged that the principal had issued a fictitious certificate without the respondent number 6 actually having worked in the.
Otherwise also, it is also violation against the 2004 OM. 2004 OM does not say anything about the appointment or authorization by the principal, my lord. Because
Court
my lord,
having
let it
produced
be
the
remanded
records, my
back,
lord.
my lord, remanded back to the director.
Why,
The
why?
OM may be considered, my lord.
Remanded to whom, my lord, who has taken the decision, so that he will again reconsider. When your lordship remand something, the decision is already there, then he has to have a relook when your lordship remand. Where is the decision here, my lord? Who will have a relook? The decision is yet to take place, my lord. Where is the question of remand?
The selection committee has declared that the respondent.
That's not final, my lord. I don't know why this argument is made again and again.
Okay.
Deeply obliged.
Obliged.
20 and 21.
Matter pertains to non-payment of family pension, my lord. The husband of the petitioner, my lord, serving as a Gao contract secretary, my lord. He died during the course of service, my lord, in the year 2010. And subsequently, my lord, the pension proposal has been filed, my lord. And now that the said proposal is pending before the respondent number 3 commissioner. Only because of that, my lord, the government filed passed letter, my lord, issued a letter, my lord, stating that, my lord, the states of Gao contract secretary has not received, my lord. And subsequently, my lord, RTP number 130 2023, my lord. It is, my lord, directed the upon the single judge judgment, but granting pension, my lord. Now that state judgment is covered. RTP, my lord, there is preferred by the state, my lord, which was
What is
dismissed.
it? What is this case about? This judgments?
Has WPC number 4397. Is the, my lord, a single bench order, my lord. It is, my lord, directed to pay the pension, my lord, under OPS, my lord. Paragraph number 11, in the instant when there is a deeming provision that service of provincial 190, it would not be covered by the new pension scheme, even if any constitutional order were subsequently passed by the authorities, as under the law, their entry into the government service was not after 1/2/2005. And that order is, my lord, challenged before the division bench. And division bench, my lord, observe, my lord, kindly see conclusion. 17, page number 17.
Yes.
In view of the aforesaid discussion and reason, this court cannot but held that the offending portion of the order dated 28/3/2018 issued by the secretary to the government of PNRD, that is ex post facto creation for the post, shall not be treated for the purpose of enabling the person concerned to receive pension and other retirement benefit, is perverse and not legally sustainable, and therefore liable to be struck down, which is accordingly done. Page 18, in view of the above aforesaid decision, discussion reason, this court dismissed the present appeal being devoid of any merit and resultantly upheld the impugned decision of dated 5/8/2020 rendered by single judge Swencho. And this, my lord, letter, my lord, I have also, my lord, that letter, my lord, already, my lord, set aside by the dividend bench, my lord. by this government letter my lord, stating that my lord, as the post was created in the year 2006, he has not shall not be treated for the purpose of enabling the person who receive pension and pensionary benefit. That part, my lord, stated by the division bench. And now, my lord, we are my lord, entitled for pension, my lord. That covered case, my lord, and the pension
What
coverage
is your case?
in item number 20, my lord. The husband of the petitioner, my lord, serving as a Gao Panchayat secretary under this category of 1 to 72 number post all over Assam, my lord.
Hmm.
His service was, he joined on service in 1995.
What is the order?
Regulation order, my lord. I have annexed, I not annexed, my lord, but I have annexed the service book, my lord. Page 13.
Hmm.
Engaged as Gao Panchayat secretary on master role basis by the ordinance in the 16/12/1993. And he joined on service on 19/6/1995. And subsequently, the service of the incumbent are regularized as Gao Panchayat secretary index Kevin Sancho, by order number PDA/393/Sancho and dated 3/7/2003, with effect from 2/6/2003, with permission to draw annual increment following the date of joining to the post. And subsequently, he died on 2010.
Where is your regularization order?
I have not annexed, but it is reflected in the service book, my
The
lord.
service book is something else, but then you should have the regularization order.
I have, at present, I have not, my lord.
In the other case, what is the other case?
Other case also, my lord, it is the under, my lord, same Gao Panchayat secretary, my lord,
Hmm.
and
But
Yes.
it's a different petitioner.
different, my lord.
Yes, respondents.
My lord, as far as case number, item number 20 is concerned, my lord, we have forwarded all his papers to the Directorate of Pension. And my lord, why they have not issued a PPO is something which the Directorate of Pension would be able to answer, my lord, because he had forwarded us a representation, first of all, to the CEO of the concerned Zilla Parishad, and the CEO had forwarded those papers to the commissioner. The commissioner office had in turn forwarded the proposal to the pension department. As far as item 20 is concerned, my lord,
In item number 20, your lordship, they have dated 6 February 2023. There they have stated that they have not received any proposal from the that the 6 February 2023. Because today, it's October 3rd, 2023, as to explain that what is the letter they have forwarded in the way we received.
But Mr. Kira Patkari, the council of the petitioner. Stop, Mr. Debora, Lennox, government advocate. How much time we require?
Lordship, 2 weeks.
There's for 2 weeks time. To enable him to receive instructions.
My lord, item number 21, my lord. This honorable court directed, my lord, to forward the pension proposal to the commission.
similar case, my lord.
Similar also.
Similar
we can
case,
get
my
the
lord.
Holds good for both.
List of 2 weeks.
The date may be mentioned, my lord, family pension, my lord.
After we get
List on 10th.
Obligation. 22 to 26.
May please your lordship.
A similar, according to the similar order, in similar cases, this is the order. This. Similarly situated person have been decided by the coordinate bench earlier. And same in order.
The salary has been released, your lordship. The grievance for the petitioner.
There is some observation made by
The
the
salary was
coordinate bench.
subsequently by communication, the salary was released.
Just a minute.
Yes.
No, without any departmental inquiry. The upon was the reference is directed to invalid. You've got your salaries. I got salary because there is observation in the impute order that without any departmental inquiry, the appointment was said to be invalid. They have stated. Where's that order? Page 32. Following the rules or rule 9 of the Assam Appeal and Discipline Rules. Page 32. Annex 9. Yes. In inviting reference to the subject, I am to say that the undersigned has initiated inquiry upon allegations of illegal appointment of grade 3 and 4 posts under establishment of Deputy Registrar of Public Service in Nagaon and Tezpur. And scrutiny the matter on 18/3/2023. It was found that the following employee had been working under the director since long, having invalid appointment and without regularizing their services, they got salary on regular basis. The petitioners are working for more than 23 years and without complying the provisions of Rule 9 of Assam Appeal and Discipline Rules, they without any departmental inquiry, their salary has been stopped and there is the observation that their appointment is invalid. So similar persons in this given that this order has made some of the observation this regard. Without this observation being not be made, there will be petition cost to me. But then there also it was not cost. But there is observation made.
That observation is made in the coordinate by the coordinated bench. If I may just read one paragraph, your lordship, the last paragraph of the order, your lordship. At page number 6.
Yes.
After considering the submission and the developments which have taken place, namely that the salaries of the petitioners have been released, and this fact not being disputed, this court is of the opinion that interests of justice would be served and the equities would also be balanced if the writ petitions are closed with an observation that unless the due process of law is followed by adhering to the rules governing the field with regard to declaring the appointments of the petitioners to be invalid, the petitioners would be entitled to the salary. Further, since the salaries have already been released effectively, there may not be any live issue to be decided. In view of the above discussions and observation made, the writ petitions are closed. So it was closed accordingly at that stage.
With this
So
observation.
if a fresh cause of action will arise, your lordship, any disciplinary action is taken. As of now, your lordship, the communication was sent to release their salary. So now they are getting their salary.
And all the facts are identical. All the facts are from the
same order.
Same order.
Same order.
This observe. But Mr. S.R. Gogoi. S.R. Gogoi, learned counsel for the petitioners. In all the writ petitions? Same. In all the five.
Yes, Your Lordship.
In all the
Equal to
five.
26.
No,
Your
no,
Lordship.
cancel it. As all these writ petitions have been common course of action and the relief sought for being identical, comma, they are being disposed of by this common order. Stop. Para. Heard Mr. S.R. Gogoi and counsel for the petitioners in all the writ petitions.
And-
Also heard Mr.
V. Rajkot, Your Lordship, for the Corporation Department.
V. Rajkot and the Standing Council, Cooperation Department, and Mr. H. Alial and the Standing Council, Finance. Yes, for the response number 6. Stop. The grievance of the petitioners in all the writ petitions pertains to the communication dated 20 March 2023 and 21 March.
Yes.
21 March 2023. Issued by the so like the pertains to the communication dated 20 March 2023 issued by the Register of Cooperative Societies, Assam, and the order dated 21st March 2023 issued by the District Deputy Register of Cooperative Societies, Naogo, whereby the salaries of the petitioners were withheld. Stop. Para. A perusal of the communication dated 20th March 2023 and the order dated 21st March 2023 would indicate that there were some allegations with regard to the manner of appointment of the petitioners as grade 3 and grade 4 to the post of grade 3 and grade 4 under the establishment of the Deputy Register of Cooperative Societies, Naogo and Tezpur. Stop. It further transpires that a preliminary inquiry was also made and there was a prima facie finding with regard to the valid against the petitioners with regard to the validity and legality of the appointments. Stop. In view of such findings, the impugned communication dated 20 March 2023 and the order dated 21st March 2023 were issued. Stop. Para. At this stage, learned counsel for the parties submits that the petitioners have been paid their salaries and are continuing to be paid till date. Stop. In that view of the matter, this court is of the considered opinion that as the petitioners are being paid their salaries, this writ petition may be closed. Stop. However, learned counsel for the petitioner submits that as there are certain observations with regard to the legality and validity of the appointment of the petitioners, the same would pose some would cause prejudice to them. And therefore, the order, the communication dated 20 March 2023 and the order dated 21st March 2023 may be set aside. Stop. Para. After hearing learned counsel for the parties and on consideration of the fact that the petitioners are being paid their salaries, comma, this court is of the considered opinion that the interests of justice would be served and the equities would also be balanced if the writ petition is closed with an observation that unless the due process of law is followed by adhering to the rules governing the field with regard to declaring the appointments of the petitioners to be invalid, the petitioners would be entitled to their salaries. Stop. Further, comma, as the salaries have already been released, comma, accordingly, with the aforesaid observations, these writ petitions are closed. Stop. So, liberty is however given to the petitioners to approach this court if any adverse action is taken against them. That much will do. And the course of action survives.
Blush.
Hearing, part third.
Shall we continue at 2? It's already just 10 minutes.
Otherwise, I had, if your lordship recalls, I had completed my arguments. It was pending for my learned friend's submissions.
Yes, Lordship, I'm completely.
Mayor Prema. My lord, I'll, with your lordship's due permission, my lord, item number 31, my lord. I have instruction to withdraw this petition, my lord.
Yeah, Mr.
M. Khatonian.
Mr. M. Katania, the counsel for the petition. He submits that he has instructions to withdraw the present petition. Stop. Who appears for the other side?
I may.
MS. E. Sharma, Learned Counsel, appears for response number 4. And
For the private response number 5.
I'm my lord for the private respondent 5. And Mr. Barber, Learned Senior Counsel, assisted by Mr.
M. Smith.
M. Smith, appears for response number 5. And Mr. T. Dayat, Learned Standing Counsel, Finance.
Yes, Lord.
Appears for response number
2, Lord.
with petition is accordingly dismissed on withdrawal.
Obliged.
Indian order এখন আছে। In fact, Lordship, on last date itself, Lordship. So far as argument and submission part is concerned, that was over, Lordship. I'll just touch the, rephrase your Lordship. So far as the points are concerned. Facts of the matter, so from my perspective. Lord. Lordship, I kindly see page 26A. Lordship, this was the notification, Lordship, by which the Assam Agro Industries Development Corporation was declared as closed, Lordship, with effect from 31/8/2006. This notification was of 26 September 2006, Lordship. In the next page, your Lordship will see at serial number 11. The Managing Director of Assam Agro Industries Development Corporation Limited, Ulubari, Guwahati 7, is requested to circulate this notification amongst the employees of AAIDC Limited. Further, he is requested to furnish the list of employees who have not allotted for VRS by indicating their designation, educational qualification, date of birth, date of superannuation, date of entry into service, and scale of pay. The list of assets, etc., etc., etc. So, Lordship, a decision was taken, Lordship. Some employees will go for VRS and others have opted for absorption of their service in any other government department, Lordship. Lordship, I kindly come to page 29. This is a letter dated 2011-2006 by the Managing Director, Lordship. With reference to above, I have the honor to submit here with a list of employees opted for VRS, as well as the list of employees not opted for VRS. So following the list is Lordship. Lordship will get the list of employees who have opted for VRS, who has not opted for VRS, Lordship. In this list, Lordship will get names of 86 persons, Lordship. 86 persons, Lordship. Up to page 34. At page, Lordship, 35. This is the repetition 3336 of 2007 by total of 667 numbers of petitioners. At 41, page 41, Lordship will get the prayer of the petitioners, Lordship. First paragraph, page 41. they perceive the state's denial to accommodate them in its department to be in imperious breach of its unqualified promise and or representation to the said effect. Lordship, it was the claim of the petitioners that they were given a promise that their services will be accommodated, their services will be absorbed in any government department, Lordship. On not being done so, this writ petition was filed. Okay, I'm reading some portion of that judgment, Lordship, at page 69. Page 69, Lordship, paragraph 42. Paragraph 42, Lordship. In the above factual premise and in face of the determination made herein, this court is persuaded to hold that the petitioners are entitled to be considered for absorption and against the vacant post enumerated in the list appended to the aforementioned letter dated 2/6/2007, annexed that in terms of the representation promise made by the state respondents for their redeployment, re-employment, following the closure of the corporation and affirmed by the cabinet in its decision on 22/8/2006, ordered accordingly. Lordship, I am coming to the last paragraph, Lordship, paragraph 43. Needless to say, the state respondents would also attend to their claim for arrear salary and allowances due to them before the closure and following the quantification thereof, defray the same to them forthwith. The petition is thus allowed in the above terms, no cost. So two directions was passed, Lordship. One, they are entitled to be considered for absorption. That is one. No direction or no mandamus to the effect that state is liable to absorb their service. It was only to the extent of consideration. And second direction was issued, Lordship, would attend their claim for arrear salary and allowances due to them before the closure, Lordship. So at this stage, Lordship, that is not a prayer, Lordship, because so far as the dues prior to the closure is concerned, Lordship, that has already been paid, Lordship. That is a part of this judgment, Lordship. That is no more a Lordship. Against that order, Lordship, state has filed one appeal 380/2008. Lordship will find at page 71. Lordship, I'm coming to page 89. Paragraph 19. This is the order passed by the division bench, Lordship, in an appeal filed by the state. Page 89, paragraph 19.
One minute. Yes.
Paragraph 19, Lordship. While it may be correct that the several government communications referred to above may not be sufficient to indicate a policy decision on the part of the state government to absorb all employees of the corporation who had opted not to be covered by the voluntary retirement scheme, yet what is plainly clear is that the fact that such employees can be treated to be returns only if they cannot be absorbed in the agriculture department. A decision as to whether an employee can be absorbed or not can only be arrived at after his case is considered against an available vacancy in the light of his qualifications and experience. Admittedly, and evidently no such exercise had been carried out and no such decision was taken in the present case, though according to us, it was incumbent on the state authorities to do so. Next paragraph, Lordship, I'm skipping the first 3, 4, 7, 8. First 8 line, Lordship, I'm skipping paragraph 20. I'm reading from the line starting with the word properly. Properly read and correctly construe the aforesaid communications, orders, and notifications make it clear that there were no options available for the employees of the corporation following its closure. The first was to go on voluntary retirement by availing the benefits under the voluntary retirement scheme in force. The second option available was to stay out of the process of voluntary retirement and await consideration of their cases for absorption, either of the options that may be exercised by an employee had cast an obligations on the state authorities to act in a particular manner. Next paragraph, Lordship, paragraph 21. Lordship, may kindly take the last 6 lines, Lordship. In the present case. Last 5 line, Lordship. In the present case. In the present case, the materials on record do not indicate that the cases of the respondents' petitioners for absorption were considered at all. The stand of the state is that there is no policy decision in force for absorption of employees of the corporation in the agriculture department. The issue is not with regard to the right of absorption, but centers around a right of consideration and eventually absorption, if any, particular employees is found to be suitable for a particular post that may be available in the agricultural department. So from the judgment passed by the learned division bench, Lordship, what the employees of the corporation had at that point of time was only the right to be considered for absorption and not a right to be right for absorption, Lordship. Only a right for consideration. Next, Lordship will come to page 94, Lordship. This is a letter issued by the government, Lordship, to the Director of Agriculture dated 10th of February 2021. Lordship, kindly see the first paragraph. In pursuance of the judgment dated 4/12/2007, passed by the Honorable Guwahati High Court in WPC number so-and-so, read with judgment dated 15/7/2009 in WN number so-and-so, and order dated 7/9/2009 in WPC number so-and-so and so-and-so, order dated demand, and as per approval of the Cabinet, in its meeting held on 27/8/2010, I am directed to convey the approval of the Government of Assam for absorption of 69 numbers of petitioners, former employees of AAIDC Limited, against the existing vacant post under Agriculture Department as shown in the list at Annexure 1 on the following terms and conditions. 1. Only the employees who have been drawing pay in the regular pay scale and did not opt for VRS will be eligible for absorption. Casual contraction employees will not be considered. 2. Employees will be considered only against the vacancies which are not to be filled up through APSC. 3. Important, Lordship, qualification and pay scale of each employee of the AAIDC Limited will be considered vis-a-vis the qualification and pay scale of the vacant post in the Department of Agriculture. 4. A list to be prepared indicating employees employee-wise suitable vacancies against which he can be considered. 5. Again, important, Lordship, the employees who are not found suitable for any of the posts carrying same pay scale and qualification will be offered lower post if found suitable for a lower post in the Department of Agriculture, subject to acceptance by the employee individually by submitting an affidavit. This was accepted. 6, Lordship, the appointing authority may adjudge the suitability of the candidates by their academic qualification, experience, and by holding written tests, typing tests, other appropriate tests, interview if felt necessary. 7, the employees of AAIDC will be considered
for absorption on the basis of merit cum seniority. However, the appointing authority can accord preference to the employees having better qualification and experience ability. 8. The employees absorbed will be given pay by the Department of Agriculture only from the date of joining in the Department of Agriculture, and they will not be entitled to any pay during the gap period, that is from the date of release by the AAIDC Limited till the date of joining in the Agriculture Department. 9. The employees absorbed in the Department of Agriculture will be placed at the bottom of the list in their respective cadre ranks, or for the purpose of seniority, then they will not have any claim of seniority over and above any of the employees already serving in the department. 10. The inter-se seniority amongst the employees so considered and absorbed will be on the basis of the select list prepared by the appointing authority in order of merit. 11. Those who will not be suitable for absorption in the department will be compulsorily retained. 12. Their services after joining the government post will be governed by the existing rules and regulations applicable to the government servants. 13. The petitioner's employees will have to give an undertaking in the stamp paper or in the form of an affidavit about acceptance of the offer and terms and conditions before joining the government post, Annex 2. 14. The candidates so appointed will not be governed by the existing Assam Services Pension Rule 1969 and orders issued thereunder from time to time. He shall have to give an undertaking as per format at Annex 3 before joining that she will abide by the new pension scheme of the government, which has been formulated in the line with the contributory pension scheme announced by the Government of India as per Finance PT Department's numbers so and so dated 6 October 2009. 15. While absorbing the petitioner's employee, the reservation policy of the state should be kept in mind. In pursuance of the para above, the state government constituted a committee comprised of the Secretary Agriculture, Joint Secretary Agriculture, a representative Director of Agriculture and MD, AIDC, to adjust the suitability of the candidates against various kinds of available vacancies in the department. The committee examined the matter at length and prepared a list, Annex 1, accordingly. You are now requested to take necessary action for absorption of the former employees' writ petitioners by the competent authority after observing the necessary formalities as per existing rules. However, the relevant documents relating to date of birth, academic qualification, caste, etc., in respect of the former employees' writ petitioners may further be verified at your end. Approval of Finance SIU Department for filling out 53 posts of junior assistant district level has already been communicated to you by this office letter number so and so. You are requested to send the formal proposal for approval of finance man so and so. So Lordship, one thing your Lordship will notice, Lordship, state government has no rule for absorption. There is no such rule or statute, Lordship. So for the purpose of absorbing this employees, Lordship, this rule was prepared by the government, Lordship, with due approval of the cabinet. Lordship, first submission I would like to make, Lordship, this rule has never been challenged. This is not under challenge, Lordship. In the present writ petition also, this is not under challenge. In the next page, Lordship, page 97.
Yes.
Here, your Lordship will see the list of writ petitioners, former employees, who may be considered for absorption. Lordship, these were the name before the committee, Lordship, who was considering the suitability of the employees, Lordship. And ultimately, Lordship will get at page 104. This is the order dated 21/3/2011, Lordship. In pursuance of the judgment dated so and so, passed by the Honorable Guwahati High Court in WPC number so and so, radio so and so. As per approval of the cabinet in its meeting held on 27/8/2010, as communicated to this directorate by government letter number so and so dated 10/2011, and subject to satisfactory police verification report, the following writ petitioners, former employees of AIDIC, are hereby absorbed under the Agriculture Department as shown against the post, pay, ban, and place of posting shown against their names, subject to the following terms and conditions with effect from the date of joining of the government post. Lordship, here, your lordship will get the terms and conditions your lordship has just said in the earlier notification, lordship. Condition number 1, lordship, the employees absorbed in the department as follows will be given pay by the Department of Agriculture from the date of joining in the Department of Agriculture, and they will not be entitled to any pay during the gap period, that is from the date of release by the AIDC Limited till the date of joining in the Agriculture Department. 2, the employees absorbed in the Department of Agriculture Assam will be placed at the bottom of the list in their respective cadre rank for the purpose of seniority, and they will not have any claim of seniority over and above any of the employee already serving in the department. 3, the services after joining the government post will be governed by the existing rules and regulations applicable to the government servants. 4, employees absorbed in the department will not be governed by the existing Assam Services Pension Rules 1969 and orders issued thereunder from time to time, but will have to abide by the new pension scheme of the government, which has been formulated in the line with contributory pension scheme announced by the Government of India as per Finance Budget Department number so and so dated 6/10/2009. He will have to give an undertaking as per format at Annexure 2, Annexure 3 before joining that he will be abide by the new pension scheme. The interest seniority among the employees absorbed will be determined later on the basis of merit. This is the list of 46 candidates, 46 persons, lordship, whose services were absorbed. Another list of 19 was also there. That is not with the writ petition, that has been annexed with the affidavit filed by the department. So total number of persons absorbed, lordship, 46 plus 19, 65, lordship. Now, lordship will come to the prayer, lordship. Page 24, lordship. Lordship, their first prayer was to give effect to the absorption of the petitioners from 26/9/2006. Second prayer fixed pay scale of the petitioners in the Agriculture Department with the earlier scale of pay which they were drawing in the substantive post in the corporation, lordship. Place the petitioners under the scheme of Assam Old Pension Scheme. Calculate gratuity from the date of joining the corporation and salary for the gap period. This is their basic prayer, lord. Lordship, my first submission, as I mentioned earlier, lordship, as the government did not have a rule for absorption, lordship, the rule for absorption was prepared by the with due approval of the cabinet, which is apparent from the letter dated 10th of February 2011. And my submission is that these rules were never challenged by the petitioners. That is my first submission, lordship. Lordship, in this regard, lordship, 2-3 judgments, lordship, I would like to cite. One judgment I have already furnished, lordship. It's WPC number 2436/2013. WPC 2436/2013, Arup Kumar Das and 5 others. One judgment is already on last date, lordship, I furnished.
I have.
Yes, Dr. I'm relying on paragraph 13 of this judgment, Lordship. Lordship, this was the
One minute,
repetition.
1 minute. Para?
Paragraph 13, Lordship. That is a paragraph of 2006 on notification for challenge Nokora paragraph. Lordship, this writ petition was filed by the petitioners, Lordship. This is the batch, Lordship, who is opted for VRS. And for the VRS is concerned, Lordship, one notification of 2006 was there. They, in this case, Lordship, they challenged some of the modification of some of the provisions of that notification, Lordship, without challenging that particular notification. And this judgment was passed in that perspective. Lordship, may kindly see paragraph 13. Thus, the ratio laid down in the cases of so and so, Lordship, has no application in this case because of the residual case of A.K. Bindal and B others. The petitioners cannot be held to be government employees, and therefore the notification of BRS cannot be said to have been curtailed any right occurred or vested upon the basic submission is that, Lordship, prior to joining of the absorption there, Lordship, they were never government employees, Lordship. They become government employees only on their absorption of service, Lordship, in the year 2011, Lordship. Second paragraph, Lordship, will see at paragraph 5, Lordship.
Para?
Paragraph 5, Lordship. Challenge paragraph 5, Lordship. The learned standing counsel for the finance department has submitted that year here to go. The learned standing counsel for the finance department has submitted that in the course of time, the government of Assam has purchased the entire shareholding pattern of so and so was as such. The AIDC was a state government undertaking, but that did not make the petitioners a government servant. By referring to the case of A.K. Bindal and another versus Union of India and others, 2003-5 SCC 163, he has submitted that once the BRS scheme has been accepted by majority of the employees of the erstwhile AIDC, the petitioners cannot re-agitate their claim for pay revision. It is further submitted that as per the government notification under memo number so and so dated 26/9/2006, the AIDC was closed with effect from 31/8/2006. Therefore, merely because the petitioners were given salary up to 31/8/2008, it would not entitle the petitioners to claim benefit of ROP of 2010 with effect from 1/1/2006, not being the part of BRS. It is submitted that the BRS policy dated 15/2/2006, as well as OM dated 15/5/2008, has not been challenged by the petitioner. Lordship, in response to this submission, Lordship, made by the Standing Counsel Finance Department, Lordship will get the decision of the court at paragraph 12 of that judgment, Lordship. Paragraph 12, Lordship. It is seen that the said notification dated 15/2006 regarding revision of revised policy on voluntary retirement scheme for the employees of the state level public enterprise of Assam has not been challenged in these two writ petitions. In the absence of any challenge thereto, this court is unable to accept that the terms of the said BRS were unconscionably and that the petitioners were compelled to accept the BRS proposal as they were unable to fight the might of the state. Hence, this court does not find the petitioners to be entitled to earn leave and case payment. But basically, what the court held, in the absence of any challenge of that notification, Lordship, Barrow.
So following the same judgment, Lordship, I am submitting in this case, Lordship, as this notification was never challenged, Lordship. This is not under challenge. It cannot be said that the terms of conditions of these notifications were imposed upon the petitioners, Lordship. They were forced to accept this notification. Lordship. Second judgment, Lordship, I am placing. This is AIR 2006, Supreme Court 2432, Lordship. I'm reading paragraph 24, 25.
The second judgment is SCC.
Uh,
What is the party's name?
This is Indu Sekhar Singh and others versus State of UP.
This is SCC.
Yes, I have given the SCC version. In my case, Lordship, I am holding this. Lordship, may kindly see the paragraph 24, 25, and 26.
Paragraphs may not match.
Same. I have tallied, Lordship.
You have tallied?
Yes, Lordship. Paragraph 24, 25, and 26.
Yes.
24. The question which arises is as to whether the terms and conditions imposed by the state in the matter of absorption of respond number 2 to 4 in the permanent service of Ghaziabad Development Authority is ultra-vires Article 14 of the Constitution of India. In this case, also, this is not even under challenge. The state was making an offer to the respondents not in terms of any specific power under the rules, but in exercise of its residuary power, assuming that the same was available. The state, therefore, was within its rights to impose conditions. The respondents exercised their right of election. They could have accepted the said offer or rejected the same. While making the said offer, the state categorically stated that for the purpose of fixation of seniority, they would not be obtaining the benefit of services rendered in UP Jal Nigam and would be placed below the cadre till the date of absorption. The submission of Mr. Verma that for the period they were with the authority by way of deputation should have been considered towards seniority cannot be accepted simply for the reason that till they were absorbed, they continued to be in the employment of Jal Nigam. Furthermore, the said condition imposed is backed by another condition that the deputed employees who is seeking for absorption shall be placed below the officers appointed in the cadre till the date of absorption. The respondent numbers 2 and 4 accepted the said offer without any demur on 3987, 281191, and 6487 respectively. Next paragraph. They therefore exercise their right of option once they obtain entry on the basis of election. They cannot be allowed to turn around and contend that the conditions are illegal. So some judgments have been cited. Furthermore, there is no fundamental right in regard to the counting of the services rendered in an autonomous body. The past services can be taken into consideration only when rules permit the same or where a special situation exists which would entitle the employees to obtain such benefit of the post of service. So this is the judgment basically, Lordship. Once you have got the entry on the basis of certain notification, Lordship, one order, without any objection, without any silence, Lordship, after taking the benefit, now you cannot turn around and silence that this was not suitable for me and this was not fit for me. That is the basic judgment, Lordship. This is I am placing. Lordship, it's a judgment passed by our High Court in a similar situation, Lordship. This is in case of Assam Minor Irrigation Department, Lordship. I'm straight coming to paragraph 61 in the writ petition, Lordship. This is order dated 3/10/2016 in WPC number 1285/2011, Lordship. Paragraph 61, Lordship. Most probably I have flagged it. Paragraph 61. Insofar the second group of petitioners are concerned, that is the petitioners in WPC number so and so, a perusal of the notification dated 30/3/2010 would go to show that it was clearly mentioned therein that absorption would be with prospective effect and that no claim for retrospective effect of joining would be entertained by the irrigation department. In this connection, undertaking were required to be obtained from the 26 employees. These petitioners have also stated in their writ petitions that pursuant to the notifications dated 30/3/2010, they had joined their respective posts in the irrigation department. Thus, these petitioners had accepted the notification dated 30/3/2010 with open eye, and after complying with the terms and conditions of the said notification, they cannot turn around and question a part of the notification. Moreover, the High Court judgment dated 19/6/2008, which is the foundation of the notification dated 30/3/2010, did not direct retrospective absorption at par with the employees who were included in the list dated 13/5/2005. Therefore, prayer for retrospective absorption cannot be accepted. Lordship will find in our case, Lordship, the direction passed by the division bench, Lordship, was only for consideration of their absorption, Lordship. Lordship, this judgment was upheld by the learned division bench, Lordship. One Lordship will get there, one writ appeal there. Lordship, kindly see the next second page, Lordship, of the judgment, Lordship. Second page. I'm taking the last 6 lines of the first paragraph, Lord. Second page, last 6 line of the first paragraph, Lord. It starts with the appellants herein. The appellants herein accepted the terms of the notifications and were absorbed accordingly in the irrigation department. The related writ petition, that is WPC number so and so, came to be filed challenging the conditions stipulated in the notification dated 30/3/2011 with prayer for a further direction that the appellants be deemed to have been serviced all throughout, notwithstanding the inclusion of their names in the BRS list. Lordship, kindly see the last paragraph. Facts appearing have received our consideration. The question for determination is whether the appellants can be allowed to challenge the conditions set down in the notification dated 30/3/2010, when at the same time they have derived benefit out of it. It is not in dispute that the appellants came to be absorbed in the irrigation department on the basis of the said notification, which has its genesis in the order dated 19/6/2008, passed in WPC number so and so. While taking benefit of the said notification, the appellants expressed no disagreement with any of the conditions stipulated therein. In fact, the appellants accepted the same and yielded to the terms and conditions set down therein. It is also seen that in the earlier order of this court dated 19/6/2008, no directions had been made towards absorbing the appellants retrospectively at par with the employees who were included in the absorption list dated 13/5/2005. By means of the related expedition, the appellants have tried to take undue advantage beyond the parameters set down in the notification dated 33/2010. We cannot subscribe to the prayer and contention set forth by the appellants, as the same are fanciful and without any legal basis. We find no good ground to disturb the findings and decision of the learned single judge insofar as the appellants herein are concerned. The present appeal being void of merit stands accordingly dismissed without any order to execute cost. Now, after going through this judgment, Lordship, my basic submission will be, Lordship, as the petitioners have never challenged the terms and conditions of this notification, Lordship. Now they cannot turn around and claim that that particular clause was not enforced upon me or imposed upon me as Lordship. Next, Lordship, two judgments I would like to place, Lordship. That is in respect of, Lordship, applicability of the old pension scheme, Lordship. I did not get the citation, so I am placing this judgment. Lordship. This is a judgment passed by the Supreme Court in the case of the state of Gujarat versus PW and Forest Employees Union, Lordship. I am coming to paragraph 12, Lordship.
Yes.
Lordship, I come to paragraph 14, Lordship. Paragraph 14. Insofar as plea at paras 2 and 3 is concerned, 2 and 3 of paragraph 12, Lord. The appellant intends to deny the benefit of GPF on the ground that, with effect from April 1, 2005, CPF scheme NPS, new pension scheme, has been introduced. However, on the basis, all such employees cannot be denied the benefit of GPF. The earlier pension scheme continues to be annual to the benefit of those who entered the service before April 1, 2005. Therefore, all those daily wagers who become entitled to get the status of regular permanent employees before April 1, 2005 has to be given the benefit of GPF. To put it otherwise, April 1, 2005 would be treated as cutoff date. All those persons who would be entitled to regularization permanent status prior to April 1, 2005 shall be given the benefit of earlier scheme of that is GPF. However, those who attain this status after April 1, 2005 shall be governed by CPF scheme and PS. Lordship, this is the law settled by the Supreme Court, Lordship. In their case, Lordship, cabinet approval was on 27/8/2010, Lordship. Second judgment, Lordship, on the same line, Lordship, paragraph 2, 5, and 6. I'm reading paragraph 6, Lordship. Lordship, in this case, Lordship, the petitioner's husband works as employee, Lordship. And his service was regularized after coming into effect of the new pension scheme. And where on the date of her husband, Lordship, she claimed family pension, Lordship. And on that issue, Lordship, this judgment was passed on. At the outset, it is required to be noted that the husband of respondent number 1 came to be absorbed in the government service in the year 2014, with effect from 2/3/2009. Till 2/3/2009, he remained the employee of Bihar Research Society, of which he was an employee and working. The old pension rules to 1950 came to be abolished, and new contributory pension scheme came to be introduced with effect from 1/9/2005. Under the new contributory pension scheme, there is no provision for pension, family pension. As per the scheme, all those who are appointed after 31/8/2005 shall be governed by the new contributory pension scheme. Therefore, at the time when the husband of the respondent number 1, who died in the year 2013 was absorbed, the old pension rules were abolished and the new contributory pension scheme was in existence. As per the corrigendum issued in the appointment order, and as per clause 6, the prior service rendered by the concerned employee prior to his absorption shall not be treated as a government service. Therefore, the husband of the respondent number 1 can be said to be a government servant and in government service with effect from 2/3/2009 only. Therefore, the husband of respondent number 1 was governed by the new contributory pension scheme, under which there is no provision for family pension. Therefore, the High Court has committed a grave error in directing the appellant to pay family pension to the respondent number 1, applying the old pension rule, which was applicable prior to 31/8/2005. The aforesaid aspect has not been considered by the High Court at all, and the learned single judge simply considered that on the date of husband of respondent number 1, who died in harness while in service, respondent number 1 is entitled to the family pension under family pension scheme. However, the High Court has not at all considered that on coming into force the new contributory pension scheme, no government employee appointed after 31/8/2005 shall be entitled to any other benefit except under the new contributory pension scheme. In that view of the matter, respondent number 1 shall not be entitled to family pension under the old pension scheme, which were not applicable at the time when the husband of the respondent number 1 came to be absorbed in the government service with effect from 2/3/2009. Lordship, one of the petitioner of the pair of the petitioners was that is that বাকীখিনি মই touch নকৰো আৰু কিন্তু দিয়াই আছে। কোনটো হেৰিখনত affidavit আছে? বাকী প্ৰায়খিনি affidavit আছে, ডিপাৰ্টমেণ্টে কৈছে মই নকৰো। Lordship, one notification word your lordship would like to go, Lordship, in the affidavit filed by the Agriculture Department, Lordship. Agriculture Department. Here, পঢ়িব পাৰিম নে?
Which affidavit?
The affidavit filed by the Agriculture Department.
Yes.
Page 16, Lordship, Annex 3. a section of employees of some SLP. Lordship, this is the notification issued by the department on 15 February 2006, declaring the VRS scheme for the employees of the undertakings, Lordship, who opts for VRS, Lordship. Clause 9 is one of the conditions, Lordship, upon which my learned colleague is relying upon, Lordship. A section of employees of some SLPs who may be absorbed in the state government departments will not be entitled to the VRS package. However, for the period of service rendered by such employees in an SLP prior to absorption in a government department, he will be paid the arrear salary, wages, basic pay plus DNS allowance only. They will not be eligible for any other component of the VRS package, as their problem of post SLP service rehabilitation will be fully mitigated by the employment in government department, Lordship. So far as this particular clause is concerned, my only submission will be at page 22 of the same affidavit, Lordship.
H
22. Annexure 5, Lordship. Lordship, in partial modification of government notification number so and so dated 15 February 2006 on revised policy on voluntary retirement scheme for the employees of state level public enterprises Assam, the governor of Assam is pleased to delete the provisions under para 9 of the aforesaid notification issued by the Department of Public Enterprises. Henceforth, paras 10, 11, 12 of the aforesaid notification will be read as 9, 10, and 11. So this was deleted, Lordship, in the year 2010 itself, Lordship. After absorption, Lordship, this clause cannot be claimed, Lordship. Benefit of under this clause cannot be claimed. Lordship, my colleague relied upon one judgment, Lordship, specifically, Lordship, 2001 SCC 644, Lordship. Sub-Inspector Ruplal and another versus Lieutenant Governor, Pro-Chief Secretary, Lordship. Lordship, in my submission, this judgment is not at all applicable in the present case, Lordship. And the reason is at paragraph 2, Lordship, of that judgment. Paragraph 2, Lordship will say, in all the above cases, the question involved is whether a sub-inspector who was appointed as such in the Border Security Port, for short BSF, when transferred or deputation to the Delhi Police in the cadre of sub-inspector executive on being permanently absorbed in the transferred post, is entitled to count his substantive service as sub-inspector BSF for the purpose of his seniority in the cadre of sub-inspector executive in the Delhi Police or not. Lordship, in this case, Lordship will find in both the cases, Lordship, he was earlier in BSF, now he is in Delhi Police, Lordship. Substantive appointment in both the cases, Lordship, under a government. In the present case, Lordship, prior to absorption, Lordship, he was not even a government employee, Lordship. That is the basic distinction between these two situations, Lordship. And accordingly, this judgment in my submission, Lordship, is not applicable in the present case, Lordship. That is my humble submission.
You are for the agriculture department.
I'm for the finance department.
Finance.
My colleague is appearing for the.
Submitted the same, and Lordship, I have submitted my written agreement, Lordship.
Well, I won't trouble your lordship much. During my original arguments, I have elaborately dealt with. The only thing that I find is what has happened to Article 226 over a period of time. Just digressing a little bit. When I had first entered the profession. In fact, I was still a student in the second year of my LLB. I had started attending the chamber of the great Mr. D.N. Chaudhary, who was subsequently elevated. After having spent about 6 months in his chamber, one thing that totally confused me was whenever I would take up any statute where a remedy is provided, there is a procedure provided. Like, for example, the Code of Civil Procedure, the Code of Criminal Procedure, let's say the Arbitration Act. The remedy of arbitration is provided and there is a procedure prescribed. So one thing that confused me perpetually was initial those days. The Article 226 does not prescribe any procedure. So during one of his free times, I posed him this question. This has completely confused me. Article 226 does not prescribe any procedure. So one of the answer that came was that after months of debate in the Constituent Assembly, Article 226 was drafted into the Constitution as an extraordinary relief. That is why your Lordship recalls that famous judgment, Dwarkanath in 1966, at paragraph 4. The very idea behind Article 226 is that your Lordship will reach out wherever there is unfairness, there is injustice. If your Lordship recalls the facts of this case, which is gone into in detail by my Lord Justice Amitabh Roy's judgment, which is annexed to the writ petition. I had placed, I am not troubling your Lordship at this stage. It is at page 35. I had taken your Lordship through the various relevant paragraphs. The background of the case was that this was one of the most successful public sector undertakings in the state of Assam. There were policy decisions taken repeatedly by the government of Assam saying that this organization is doing very well. We need to further support it. It has been able to reach out in the agriculture sector. It has been able to reach out into the remotest corners of Assam, facilitating the development of agriculture at various levels, at the grassroots level. In spite of that, ultimately, the government started digressing from its own policy. It started giving out contracts to private parties. And that is how this organization started coming down. Ultimately, your Lordship again recalls, that is also recorded in the judgment. A PIL was filed by none less than 2 former chief ministers of the state, saying that this is an organization which is doing so well. Why is the government showing a stepmotherly attitude to this organization? Why is it diverting all the contracts which were being, the works that were being undertaken by this PSU? Why is the government giving it to the private sector? If this continues, this organization will die. In spite of that, the government continued. These employees, they resorted to agitations. They filed repeated writ petitions where interim protections were granted. There were NITs being floated by the government, inviting tenders from private parties. Those were stayed by this honorable court. In spite of that, they repeatedly flouted. Ultimately, it led to the closure. Rightly or wrongly, these were employees under a public sector undertaking where the government of India had 50% stake and the state of Assam had 50% stake. They were, for all practical purposes, they were enjoying benefits of a government service. They were entitled to pension. They were entitled to all the rules applicable to the state government employees were applicable to these employees. Otherwise, for all practical purposes, they were at par. So it is in this background, if your Lordship will allow me to place that paragraph once again of the judgment, it is in this background that the judgment starts at page 35. And if your Lordship will come to page 63. The last paragraph in that page 63. The revised policy on voluntary retirement scheme for the employees of the state level public enterprises Assam was circulated by the aforementioned notification dated 15/2/2006. The benefits of the VRS package were in respect of all state level public enterprises in the state, irrespective of whether those were to be closed or revived or could afford to discharge the dues of their employees from their own resource generation. Clause 9 thereof, having a definitive bearing on the present adjudicatory process, deserves to be extracted. This very clause was read out by my learned friend just now. A section of the employees of some SLPs who may be absorbed in the state government departments will not be entitled to the VRS package. So the first thing it says is, those who apply for absorption, they will not be entitled to any of the benefits under the VRS package. Why is explained in the next sentence, madam. However, for the period of service rendered by such employees in an SLP prior to absorption in the government department, he or she will be paid the area salary, wages, basic pay plus dearness allowance only. They will not be eligible for any other component of the VRS package, as their problem of post-SLP service rehabilitation will be fully mitigated by employment in the government departments. What it said was that these people will not be entitled to any benefits of the VRS package, since they have applied for absorption, as their all service conditions will be fully mitigated by way of employment in government departments. Therefore, we are not allowing you any other benefit. And this particular phrase of fully mitigated, that is what led to this judgment. And if your lordship will now come to para 31 in that same page 64. Clause 9 is categorical to the said effect, which clarifies that they would not be eligible for any other component of the VRS package, as their problem of post-SLP service of rehabilitation would be fully mitigated by their employment in the government departments. So the genesis, the foundation behind this judgment is this particular clause. And your lordship, if your lordship sees the date of the judgment, which is reflected at page, my lord, 41, your lordship will kindly see the date of the judgment. It is 4/12/2007. And the notification deleting that particular clause came in 2010. They ought to have filed a review of this judgment, because this judgment took note of clause 9 to give the relief to the petitioner. The very genesis, the very foundation of the relief granted to the petitioners was clause 9 of that notification. Why? Because all benefits or service conditions will be fully mitigated. And when we say fully mitigated, all the judgments that have been placed by the other side, your lordship will find a very fundamental difference. All these pertain to regularization of service. There is a very fine but fundamental difference between absorption and regularization. Absorption means that he was in substantive employment earlier, duly selected and substantive employment. Regular service, as the word itself connotes, the earlier period was irregular. The entry might have been without any selection. The entry might have been without any advertisement. The entry might have been through the back door. Something that was irregular is regularized. So therefore, retrospectively, you cannot claim the benefit. But when it comes to absorption, you are already in substantive employment. These same benefits, just to make the illustration easier, assuming this closure of the public sector undertaking had not taken place, they would have been entitled to all the benefits. They would have been entitled to the earlier pension scheme. So therefore, when this word fully mitigated is employed in the notification, and this honorable court takes note of that in paragraph 31, and thereafter proceeds. In fact, my lord will kindly come to para 33 also one. It's a slightly longish paragraph. I'm not troubling your lordship with the entire paragraph. At paragraph 33, page 65, towards the bottom, about 4 lines from bottom, there's a sentence starting in the right hand side. By the memorandum, approval of the cabinet was thus sought for closure of the AAIDC in principle, so that the agriculture department could implement the voluntary retirement scheme as per the guidelines by notification number so and so dated 15/2/2006. When the cabinet approves, the cabinet takes note of this notification. It clarified in categorical terms that the implementation of the voluntary retirement package would be as per this notification. The next paragraph, the official records reveal that the cabinet memorandum in the form submitted was accepted and the proposal for the closure of the AIDC under the administrative control of the agriculture department was approved by the cabinet on 22/8/2006. So when the cabinet approved, it took note of 15/2/2006 notification, which includes clause 9. Because the cabinet approved it on 22/8/2006, naturally, the deletion had not obviously come into force till 2010. So when the cabinet approved, cabinet was fully conscious of the fact that by virtue of clause 9, the persons who have applied for absorption would be getting the benefit of clause 9. And having taken note of all these things, my lord, again in paragraph 37 also this notification, if your lordship kindly comes to page 67, when this honorable court was dealing with this cabinet decision, once again your lordship will find in paragraph 37 that notification of 15/2/2006 is taken note of. And ultimately, the direction which your lordship will find at page 69. Para 42. In the above, I'm sorry, has my lord got it? In the above factual premise and in the face of the determination made herein, this court is persuaded to hold that the petitioners are entitled to be considered for absorption. The word he used is categorically absorption, which my lord presupposes that they are already in substantive employment. Otherwise, absorption cannot take place. Otherwise, the word would have been either regularized or inducted, something like that. The word employed is very consciously absorption. Against the vacant posts enumerated in the list appended to the aforementioned letter dated 2/6/2007, in terms of the representation promise made by the state respondents for their redeployment, re-employment following the closure of the corporation and affirmed by the cabinet in its decision on 22/8/2006, ordered accordingly. Why it was directed? Because this honorable court found it to be a promise held out to this employee. And by invoking the doctrine, the principle ingrained in the doctrine of promissory estoppel, this direction was issued. And if we continue further, madam, next subparagraph, as the petitioners wait in bona fide expectation and understandably that with the sudden turn of events, they have been left high and dry with their families, the process as directed should be completed within a period of 6 weeks from the date of receipt of the certified copy of this order. Next para. Needless to say, the state respondents would also attend to their claim for area salary and allowances due to them before the closure, and following the quantification thereof, defray the same to them forthwith. And this was, what was the direction that you will do it in six weeks' time? They did not. Now they are opposing our prayer for area salary during the period which they took. If your lordship now takes note of the dates, madam, this judgment came on 4/12/2007. They filed a writ appeal. This writ appeal was disposed of on 15/7/2009. The writ appeal was dismissed. Thereafter, we filed a contempt. After the contempt was file, they ultimately issued orders absorbing us. Now they are saying that you will not be entitled to the salary for this period. But you absorbed us. It was a promise you held out to us that you will absorb us. When you did not, this honorable court invoking the doctrine of promissory estoppel directed our absorption. You failed to comply with the specific direction issued by this honorable court that absorb them. They have been waiting, bona fide expectation. Absorb them in 6 weeks. You do not do it. And now you take it as a defense to say that you did not render service during this period, therefore you will not be entitled to salary. If I pose a question to myself, will this be fair? Will this be justice? That is why I started my submissions by saying, I don't know whether I'm carrying Dwarkanath or not. Dwarkanath, that is what, while interpreting Article 226, that is what the apex court said. Wherever, while your lordships are exercising jurisdiction under Article 226, wherever your lordships will find injustice, wherever your lordships will find unfairness, your lordships will reach out and grant the relief to the bona fide citizens of the country. Now, my lord, entire genesis being clause 9 of 15/2/2006, and this honorable court having taken note of that, having taken note of the promise held out, and having issued the direction for absorption. These people were ultimately, after 4 long years, they were absorbed in 2011. Now, having done so, this simple question, although we can get into all these technicalities of this notification, that judgment here, that judgment there, ultimately, what is the principle? The principle is the very word absorption, as I was pointing out to your lordship, envisages, presupposes a substantive appointment where, in this particular case, a public sector undertaking where government of Assam had 50% stake and the government of India had 50% stake. It is no one's case that we were not in substantive employment there. Having done so, S.I. Ruplal's case, the distinction that has been sought to be brought out by my learned friend is that there it was from either perhaps from BSF to Delhi police. Yes, ma'am. If your lordship kindly, my learned friend placed paragraph 2. In all the above cases, the question involved is whether a sub-inspector who was appointed as such in Border Security Force, for short BSF, when transferred on deputation to the Delhi police in the cadre of sub-inspector executive, on being permanently absorbed in the transport post, is entitled to count his substantive service as sub-inspector in BSF for the purpose of his seniority in the cadre of sub-inspector in the Delhi police or not. My learned friend wanted to carve out a distinction, saying that in this particular case, it is from a public sector undertaking to the state government. And here it is from BSF to Delhi police. Does not matter. Both of them are completely autonomous independent organizations, like in the present case. BSF is a completely separate entity and Delhi police is a completely separate entity. From one substantive appointment in the same rank and status and cadre, they came from BSF to Delhi police. Here, from the same rank and cadre, from a public sector undertaking to the state government. What would apply, as I was pointing out in the earlier case that I was arguing, what applies is the ratio. And if your lordship kindly comes to para 15, the ratio is at para 15. We will now take up the question whether the appellants are entitled to count their service rendered by them as sub-inspectors in BSF for the purpose of their seniority after absorption as sub-inspectors in the Delhi Police or not. We have already noticed the fact that it is pursuant to the needs of the Delhi Police that these officials were deputed to the Delhi Police from BSF following the procedure laid down in so-and-so of the rules and subsequently absorbed as contemplated under the said rules. It is also not in dispute that at some point of time in BSF, the appellant services were regularized in the post of sub-inspector and they were transferred as regularly appointed sub-inspectors to the Delhi Police Force. Therefore, on being absorbed in an equivalent cadre in the transferred post, we find no reason why these transferred officials should not be permitted to count their service in the parent department. This is the ratio. At any rate, this question is not re integra and is squarely covered by the ratio of the judgments of this court in more than one case. Since the earlier bench of the tribunal relied upon Madhavan case to give relief to the deputationists, we will first consider the law laid down by this court in Madhavan case. This court in that case, while considering a similar question, came to the following conclusion. We may examine the question from a different point of view. There is not much difference between deputation and transfer. Indeed, when a deputationist is permanently absorbed in the CBI, he is under the rules appointed on transfer. In other words, deputation may be regarded as a transfer from the government department to another. It will be against all rules of service jurisprudence if a government servant holding a particular post is transferred to the same or an equivalent post in another government department. The period of his service in the post before his transfer is not taken into consideration in computing his seniority in the transferred post. The transfer cannot wipe out his length of service in the post from which he has been transferred. It has been observed by this court that it is a just and wholesome principle commonly applied where persons from different sources are drafted to serve in a new service, that their pre-existing total length of service in the parent department should be respected and presented by taking the same into account in determining their ranking in the new service cadre. The ratio is this, my lord. This sentence, it has been observed by this court that it is a just and wholesome principle commonly applied where persons from different sources are drafted. Here is a situation, my lord. The source is a public sector undertaking where we were serving in equivalent cadres appointed in accordance with law. So therefore, we could have been absorbed in similar posts, similar cadres, similar ranks with similar pay scales. So the only question that would remain is whether our past service needs to be counted or not. And this, the ratio laid down in SI Ruplal, particularly in paragraph 15, perhaps fully nails the case. But if that be so, Madam, each of the prayers that we have made, although I had supported them with separate provisions of rules or executive instructions. But if your lordship accepts this SI Ruplal proposition and the judgment rendered in the earlier round of litigation by this honorable court, there cannot be, in my humble understanding, there cannot be a scope for not counting our past service, since it was in a substantive capacity. And if that be counted, each of the prayers are merely consequences thereof. Those have to be given to us by the authority. If your lordship holds that our past service cannot be wiped out. And that is what has been held in SI Ruplal. Otherwise, your lordship will kindly see the situation, what happened, what has happened. And in reality also it has happened. A person accumulates earned leave, gratuity, various components of his entire service career. There were some people who were absorbed at the age of 57. This absorption took place at when they were 57. Only 3 years of service left. And if your lordship applies the test as has been sought to be propounded by the opposite side, that man at the age of 57 is faced with a situation as if he is a fresh appointee. And all his work put in, maybe at the age of 25, 26, 30, these decades of service rendered by him is completely wiped out. The question, therefore, is whether that would be a fair way for the state to deal with its citizens. Whether it will be a just proposition to deal with the citizens in such a manner. So therefore, my lord, in my respectful submission, this is a case where your lordships, by taking a cue from the earlier judgment rendered by this honorable court, and by applying the ratio laid down in S.I. Ruplal's case, will record a finding that we are entitled to count our past service. And if that be so, if your lordship accepts this submission, my lord, the rest of it will automatically follow. That is my limited submission before your lordships, my lord. And each of those prayers that we have made, I had, my lord, if your lordship so desires, I can give a very brief note. I had prepared a very brief note on the rejoinder that I have given. And if your lordship so desires, I can prepare a very short note for in respect of each of these prayers, how, under what provisions of law we are entitled.
When can you give?
Your lordship will give me today's by Monday. Can it be next week sometime? I'll try to give it by, if I'm not available also, one of my juniors will hand over to the court master by Monday.
Nayak also can give.
They have also given, I think.
Agriculture has given.
I'll prepare a very short 1 or 2 pages so that it is easy to.
Okay, heard Mr. I. Chowdhury, the senior counsel. Assisted by
Yes, Vishwakarma.
S. Vishwakarma, the counsel. Also heard Mr. P. Nayak, the standing counsel, finance department. And MS. R. Bora.
Yes.
Learned standing counsel, agriculture department, correct?
Yes.
For the respondent number. One, two, three. Finance will be respondent 5, correct? And respondent 4, anybody? Assam Agro?
That has become defunct now. So.
I'll just keep it 13 part, just submit, then we'll close.
Mal. Your lordship, in that case, can fix it on next Tuesday. On that day, we'll submit.
13 part. Please for 40 hearing on.
It will be, I think, 10th.
10th.
Oblige.
Lordship, in that case, I need the further 2 weeks time to file our affidavit, Lordship. And the
Was
executive.
there, something was there, isn't it?
Yes,
You were
Lordship.
taking up the matter.
Yes,
They're supposed to give the instructions from the Dibrugarh University.
Correct.
Lordship, that
First,
the-
Mr. Majumdar.
yes, Lordship, that executive council has all decisions of the executive council has already taken the decision, Lordship. Probably it is in favor of the petitioner, Lordship.
That is what you have been mentioning from the past.
Yes.
I think more than a month back.
And why
And,
2 weeks needed, Melody? If they want to
that-
file an affidavit,
Then
let it,
13 on 13, Lordship, next, on 13.
Okay.
let them file Melody a positive affidavit
Yes, Lord.
in that.
Who appears for the first read petitioner?
I am with you.
Heard Mr.
Arson.
Arsenal and counsel for petition in WBC. 7540 of 2017. As well as Mr. S. Datta, then a senior counsel, assisted by Mr. S. Datta. Learned counsel for the petitioner in WBC 5044 of 2017. Stop. Mr.
H. Bezbulwa, appearing on behalf of our
Yes, Vura, appearing on behalf of Mr. R. Majumdar, then standing counsel, Dibrugarh University, press for some time. Stop. Press or not. When do you want?
Lordship, on 13th. I will file our affidavit, Lordship.
13th is a Friday.
Yes, Lordship. Certain lordship that Mozumdar will be out of station till 12 lordship. So may I pay?
Why can't we have it on a hearing day, isn't it?
Let us see what they file. On 13, it can be fixed.
Okay. Okay, then appearing on behalf of praise for some time to enable him to file an affidavit. Praise allowed, list on 13th.
Much of that.
Much.
My lord, it has been marked as parted. I think it will be remained as parted.
Yeah, actually it is not parted also usually.
My lord, your lordship heard it the last time.
Hmm.
Then in between, my lord, they have said that.
Yeah.
Obliged.
30.
None.
They are not sure. And for the respondents.
None appears for the petitioner. Mr. B. Goswami. Standing counsel.
One additional.
You are appearing as a standing counsel.
Now appearing as additional advocate.
Okay, then additional advocate general Assam appears for the
Respondents.
respondents. List after
1 and 2, my lord, 3 is central government.
1 and 2.
After as your lordship.
2 weeks.
33.
My lord, in this case pursuant to order dated 2/1/2023, I have filed one affidavit, my lord. Copy was not served. They have asked me morning the copy to serve. I have to serve the copy. So my lord, in the next week, it may be taken up. Meanwhile, I'll serve the copy.
Can request made by Mr.
J. Sharma.
J.
Petition.
Sharma, learned counsel for petitioner. List the matter after 1 week.
After. Good luck.
34.
Yes, that is not present.
Where the others?
SC, Assam Gramin Vikas Bank. Earlier council died, your lordship. Mr. D. Banerjee, he died, but someone else was to be present here. It has been, some other advocate has been engaged, or I have heard. And none appears.
You can check out. I'll adjourn the matter. Heard Mr. Asham. Learned counsel for the petition.
Next week, your lordship.
None appears for the Assam Gramin Vikas Bank. List the matter after 1 week.
Date may be fixed.
You want a date?
10th.
12th.
35 and 36.
May I please, my lord? My lord, it's a pay parity matter, but I need not go that far. My lord, I've made a small comparison statement. My lord, we are working in the Assam Police Radio Organization, APRO. Now, this comes within the fold of the police, total police force. There are various wings, and this is one of the wings. Now, my lord would have that. The 5th pay commission, my lord. I have not gone before that. The parity is there, my lord, even before that. Now, if my lord takes up the 5th pay commission, DEF, if I may use the word, it's the normal policeman, normal policing staff. Armed branch and unarmed branch under Director General of Police. ASI will be given 30106075 under 5th pay commission. Now, in APRO, there are two categories of posts of ASI. The lower one is ASI WTO grade 2. My lord would see it is the same pay scale, 30106075, which is the ASI normal, my lord. Now we have a higher post. From here, there is a promotion. We have to pass exams, then promotion. That is, my lord, 313066600. Higher. Then constable. These are the two posts, my lord. Head constable 2890 normal police, and in APRO also same. Now comes the 6 CPC. 6 CPC, the pay band is 5,200, 20,200. My lord, earlier it was given 2,100, that I have not brought in, but after upgradation, my lord would find grade 1, 2,500, they have equalized it with the normal police. Here they put it, my lord, as 2,400. And my lord, head constable and the constable grade 2. Subsequently, it has been redesignated a head constable WNTO in pursuance to orders of this honorable court. So everything same. Now comes the, my lord, 7 CPC. Here, once the CPC pay commission report was published, therein, my lord, ASI UB was given 6,200. My lord will just ignore that. Then, my lord, the bottom part, my lord, will ignore 6,200. ASI grade 1 was given 6,400. Again, my lord, the higher pay scale was brought back. And the lower one, like this 5th CPC, it was given 6,200. Same. Head constable, my lord, for them it was 5,600 and we were given 6,200. A little bit higher. Now what happened? They publish a further amendment. In that amendment, they raise the ASI pay of the normal police to, my lord, with effect from 15/6/2018 to 7,400. Whereas we have been kept stagnant. Here also, 5,600 was given. That was raised to 6,800. Now, the plea taken in the written statement, in the affidavit filed by the finances, because the pay commission did not make any recommendation with regard to, specifically with regard to APRO, so we are not in a position to give it. Now, I'll take my law through that, wherein the pay commission, my lord, discussed in general all the police segments from constable to ASI and then fixed pay scales accordingly. That is exactly what was given subsequently to them. This was not given to us. And how I can establish that? My lord, the whole grievance that we have as an APRO employee was being projected before the pay commission and the anomaly committee by the All Assam police organization. We have an association, my lord. That association was fighting for us. When my lord sees here towards the left hand, right hand side, my lord, down below, ASI WTO grade 2, 6,200. Constable also 6,200. My lord has got it. Both the posts, promotional post, down below, my lord, right hand side. Both the posts under the 6 CPC, 7 CPC were given 6,200, 6,200. This grievance was placed before the anomaly committee after this was published. The anomaly committee said, pay commission has made detailed references. Why should we go into it? That will be implemented. So that shows that recommendation is for the police force as a whole, not specifically for, my lord, the general police as we know, my lord. This is basically the case, my lord. If my lord is pleased to accept this, my lord, then our pay, which there are many recommendations here from the authorities. They closed it only with the plea that pay commission had not taken it. Then how did you fix our pay like this, my lord? You could not have fixed our pay like this. Mr. Rajiv is here, my lord. I can then proceed. If my lord can take up, I'll not detain your lordship with the requisite things. I'll only produce the requisite things, my lord. Page 73. That is the recommendation, my lord.
WBC?
WBC, my lord, sorry, 6540. My lord will have page 73. That is the recommendation down below, my lord. The commission recommends that the GP for constable and other ranks up to the level of ASI should be as follows. Constable 2,200.
1 minute.
My lord will have 6540. My lord.
6540.
Ratul.
Yes. Page 73.
Lordship.
Roman 1, 2, 3, 4 is there, correct?
Malad, it's like this one. The page before that would be this one. Seventh Assam Productive Committee.
Oh.
The next page, Malad. Our Roman 1, 2, 3, 4. I'll be, Malad, just after that, 2, Malad, down below.
Okay.
The commission recommends that GP for constable and other ranks up to the level of ASI should be as follows. Constable 2,200, Lance Naik, head constable 2,700, ASI 2,900. So 2,900 conversion is 7,400, which was given from 15,6. Now, my lord would come to the anomaly committee. It starts at page 80. I'll have my lord's attention at page 82, my lord. My lord would see this is by the All Assam Police Association.
Oh.
My lord has got it.
Yes.
Now they say the grade pay of SI of police and inspector of police may be enhanced. That is the normal police. The association demanded equalization of APS junior with APS senior to consider higher pay scale for grade 1 ASI of APRO. Higher grade pay for grade 1 constable operator so-and-so may be considered. Now, my lord will see the observation made. The anomaly committee noted the pay commission has made suitable recommendation in this regard. So the recommendation is, my lord, at that page 73 clause 2, my lord.
This is a 7 pay.
7 pay commission. And this is the anomaly committee to the 7 pay, my lord. Now what has happened, my lord? If lordship can come to page 106, that's the conversion, my lord.
Yes.
My lord, in the PIP CPC, we were given 2,500 ASI and ASI, the normal police also was given 2,500. So the conversion would be, my lord would say 6,400, which I was given, my lord. Page 106, my lord. If my lord can have that sheet which I have given, my lord will see in 6 CPC, ASI UB AB 2,500, ASI WT WO grade 1 2,500. So the conversion of 2,500 middle against 5,200, 20,200, 2,500 conversion is 6,400. My lord has got it. But the 6 CPC, 7 CPC, when it was considering, said that it did not prescribe, my lord, new pay scales, new pay bands, grade pays. It only enhanced the existing grade pay. From 2,500, it enhanced it to 2,900. If my lord can have page 73 for a, I'm troubling your lordship, page 73 for a moment, my lord. We have. My lord has got it.
Yes.
Here the last E. ASI should be 2,900. And this is the conversion table. So 2,900 would be 7,400. But the pay commission report, when it was published, they were given 2,500, corresponding was, my lord, 6,400. This is the recommendation, but initially it was not done. Subsequently, my lord, what they did was, they published an amendment. I'll place that amendment straight away, my lord. That will clarify the issue. Yes, if my lord can come to page 95, my lord, first.
Yes.
My lord, the recommendations were earlier. Subsequent to that, this was published in 17, my lord, March 2017, 7 CPC. 7 CPC, my lord, Pay Commission recommendations accepted by the government and published in March 2017. Then they amended that, my lord. This is the amendment, 309 amendment. My lord would see ASI UB, they prescribed 2,900. My lord has got it.
Yes.
Corresponding 7,400. That is, my lord, which I said from 15/6/2018. I'll just show 15/6/2000. Just place this, my lord. Then head constable 2,700. This is in terms of that pay commission recommendation. It should have been 2,500, but they took it as 2,700, and the corresponding is 6,800. Now what they did, my lord, after a month, if my lord can just come over to page 94. The first line, my lord. In cancellation of the earlier notification number so-and-so dated 14/5/2018. My lord has got it. 14/5/2018 is page 95. Now my lord would see. ASI UB 2,500. That's the actual that they were getting. That has been raised to 7,400. And head constable 2,400, which has been raised to 6,800. So my lord would find under 7 CPC I have written ASI UB initially GP 6,200, thereafter enhanced with effect from so-and-so to 7,400. But the corresponding enhancement in ASI APR was not paid. Now, my lord would see the pay that was given to us, the rejection order, that my lord would find at page 127. From where they have got this, I don't know, my lord.
Yes.
With reference to the subject cited above, I am directed to say that no recommendation of 7 or anomaly committee 2000, my lord will mark these words, my lord. No recommendation of 7th APC or anomaly committee for revision of pay in respect of APR. You are therefore requested to resubmit the matter during the next pay commission. Then again, the association under banner room which we, my lord, perform, page 130, All Assam Police Association. They move the government again, my lord. Now, my lord, I'll have my lord's attention that quoting is made of in the bold of the pay commission recommendation, the paragraph next to that. In this regard, the Honorable Director General of Police Assam submitted 2 numbers of proposals with financial implication to the Finance Department. Wide letter dated so-and-so, so-and-so. As per request, so-and-so, where amendments have been made in the schedule of so-and-so and enhanced grade pay of all rank of Assam Police from Constable ASI except APRO personnel. In case of the set file 2 of APRO, so many queries 4 times have been made by PRO and the authority submitted the reply with justification accordingly. As per letter issued by so-and-so, so-and-so stated that there is no recommendation of 7 CPC for revision of pay in respect of so-and-so and request to submit the matter in next pay commission. Now, in this regard, I am to state that the Assam Police comes under direct control of the Department of Home Affairs, Government of Assam, and is headed by the Director General of Police, Government of Assam. To meet the increasing demands of law and order and also peculiar situation obtained in the state threatening national security, the following branches have been working under Director General of Police, and we are there, Assam Police Radio Organization, Bureau, Criminal, Special, District, so-and-so, so-and-so. There are 16 my lord bodies given. My lord will note one thing. Home guards have not been specified here. I'll show why I'm making that submission. Home guards have not been specified here. The normal police force that they consider, home guards are not there. Then what they say, my lord. Hence, as per the direction of the 7 CP Assam so-and-so, with the report of the committee to examine the so-and-so, dated so-and-so, so-and-so, it is found applicable to all the above 16 branches of Assam Police, allowed to draw the recommended grade pay in the rank of so-and-so to ASI, including APRO. There is no question arises APRO will be recommended separately for grade pay, and also no need to recommend it by anomaly committee, as 7th APP directly recommended only for Assam Police. APRO is also one of the important branches of Assam Police to support law and order enforcing it by providing reliable, secure and high-speed communication towards effective maintenance of law and order, prevention and detection of crimes and criminals. Also provide so-and-so, so-and-so, so-and-so. Then they made a prayer that this should be extended. Now, my lord has seen the rejection order. They say two things, my lord. For my sake, my lord, if my lord can come back to 127. 127, my lord. My lord will see they have rejected that and 7th APPC 127, my lord.
Yes.
Or the anomaly committee had not made any recommendation. Now, I'll trouble my lord with page 73 again. My lord would see the last paragraph once more. The commission recommends that GP for constable and other ranks up to the level of ASI should be as follows. It does not say, my lord, ASI, UBAB. It says only ASI. Constable so-and-so, so-and-so, Havildar so-and-so, ASI so-and-so. The same GB shall be allowed for the equivalent ranks in Home Guards. Because, my lord, Home Guard, normal that police force, it was not included. That is why there was an extension made. And in the report, they say that there was no specific recommendation for APRO. APRO, it's not required. It was a general recommendation made. Now, how I can, my lord, establish that? I'll just have my lord's attention. The anomaly committee report starts at page 80. I'll have my lord's attention at 82, ma'am.
Yes.
My lord, I had shown from that sheet that 6,200 is for ASI grade 2 and head constable also 6,200 were given. My lord has got it.
Yes.
Now, that was taken up by All Assam Police Association before the anomaly committee, that this is a disparity, kindly redress it. Now, my lord would see the observation. The anomaly committee noted the pay commission has made suitable recommendation in this regard. So, now for the authorities to say that there was no specific recommendation will not hold water. Because the anomaly committee also referred to clause 2 at page 73 to say that recommendation is applicable. Now implement it. Now, my lord, for reasons unknown, we have been extended with a stepmotherly attitude. And we are forced to draw our pay at a lower stage. That is why we are before your lordship. Now, my lord would have page 133. Sorry, my lord, 132. This is constable operation grade 2. We are not much bothered with that. The next page, my lord, head constable. My lord would see it was 2,400. We have been given 6,200, my lord, revision. Pay band is same for everyone, but the grade pay 6,200. If my lord comes to the chart, my lord would find the head constable UBAB were also having 2,400, same like us. And we were also having 2,400, but they have been given 6,800 only because of page 73, application of page 73, para 2, we have been denied that. This is my case before your lordship. Now, the affidavits that have been filed, I may just take my lord through that. My lord, the first affidavit is by one, the Superintendent of Police Communication, Ghanshyam Das Narjari, page 150. Man. My lord would have, huh? My lord, in this affidavit, they say that everything is equal. But we have not been given, so that revision was made. Otherwise, para 4, 5, they all say that the parity, historical parity is always there. Now, the finance department affidavit, my lord, that's vital. Starts at page 162, my lord. My lord would have page 168.
Yes.
My lord, just after Annexure A, the paragraph, sub-paragraph, the same grade pay was allowed for the equivalent ranks in Home Guards. But there was no such recommendation for personnel under APRO. My lord, if I take that plea, the other 18 organizations which have been listed, there was no specific recommendation for them also, my lord. If it is taken that this recommendation was only for UBA and AB, they are for the, my lord, DEF. The other organizations don't come within that, my lord. It's separate. CID, Bureau of Investigation, they all separate, my lord. So for them also, there was no specific recommendation. Only said that because Home Guards don't come within that, that recommendation said extend it to Home Guards also. Now, Home Guards are getting it. APRO employees are not getting it. We have only two categories before, my lord, Head Constable and ASI. We are not getting it. And their simple prayer is that because did not make, then why did the anomaly committee, while, my lord, considering our grievances, make that observation? Because it said detailed observations, detailed recommendations have been made by the pay commission, so we'll not go into it. This factor, my lord, and again, page 169. This is clearly perverse, my lord. Page 169, if my lord can have, just after Annexure C, my lord. As regards personnel under APRO, neither the 7th APPC nor Anomaly Committee 2007 has made any recommendation for upgradation of grade pay. My lord has seen the recommendations of the Anomaly Committee. It said, Pay Commission has already made, why should we come in? That will be implemented. But you have not done it, my lord. My lord, just to take my argument a bit further, for my lord's assistance, if I may just show. Well, I'll hand over the 7 CPC recommendation. My lord would find that there are different organizations. There are, my lord, Border River Police Organization. There is the General Department, that is, my lord, Director General of Police. Here, Assistant Inspector of Police, UBAB. If their thing is, the recommendation can only be for UBAB, not for anything else. But the recommendation does not say ASI, UBAB, unbranched or unbranched. It does not say much. It says general. And, my lord, in our APRO also, we have similar posts. And from before, my lord, this was the system that was being followed, subject to what my friends can say. In that view of the matter, my lord, the parity that was given to the general police is also to be extended to the two categories, Head Constable, then, my lord, ASI grade 2 and ASI grade 1, appropriately. My lord would see, when the notification was made, ASI grade 1 was placed at a higher stage status, 6,400. Whereas normal ASI, grade 1, normal ASI was placed in 6,200. And the grade 2 ASI was placed in 6,200 similar. fifth pay commission, same thing, madam, came back. But when they tried to implement it, because of a wrong notion of the matter, this occasion. So my humble submission before my lord is that the pay has to be substantially revised with effect from the date the others were given, and the areas have to be given to. This is my humble submission. Because the ground that they have taken, not sustainable. Because what the pay commission said is reflected in the anomaly committee's report. It said you go back to the recommendations there. I may just read that, my lord need not trouble my lord. I'll just read that. The anomaly committee noted the pay commission has made suitable recommendations in this regard. So the only recommendation pertaining to the police from constable to ASI is, my lord, para 2. There is no other recommendation. And nobody has said that there is some other recommendation also for them. This is not applicable. Their case is because there is no specific mention. So we are not giving. So then they should have limited that to, my lord, DEF, the normal police, and the home guards. Others should have been not given. Everybody given, only APR or not given. And the historical parity that was there, that was set aside. So, my lord, it's a clear non-application of mine, which requires my lord's interference in the matter. Subject to what my friends would say, man, this is my case.
Who are the other parties?
My lord, the home department and the, my lord, my friend for the finance.
Finance. So who's arguing first? Finance.
The home department is the administrative department out here. Under whom, my lord, the petitioners are the employees. Employer is the, my lord, the home department. And the finance department is only the nodal department, my lord, to take care of, my lord, the pay structure at this thing. So if my lord may be pleased to take up the affidavit, my lord, filed by the respondent number 2. My lord, my learned senior colleague has just now drawn my lord's attention. The affidavit filed on behalf of the finance department. There.
Prabhujari, how long will take?
Sometime, at least I will have to read out this affidavit.
No, I will, someone to.
Lordship has already heard, my lord, the petitioner side, my lord, with all respect. If Lordship may be pleased to keep this matter part heard. And fix a date, my lord.
Part UK Nair and Senior Counsel, assisted by MS.
S. Hazarika. S. Sharma.
Counsel for the petitions. Also heard Mr. Arver Bhavudari, Leonard Standing Counsel Finance.
Finance.
And Mr. D. Bora, Leonard Government Advocate. So, 14 part. Please for further hearing again. This week, maybe I will not be sitting.
Next week, whenever it's my lord convenient.
10th or 12th, any date you can.
12th, my lord. 10th or 7th.
Yes, 12 October, my lord.
Lord.
Thursday, yes, my lord.
Fine.
Thursday.
It's a
my lord.
Thursday, my lord.
Thursday hearing there, my lord.
It's a 12th.
My lord. And so obliged.
Much obliged.